Wait, please, Your Lordship. My lord, with regard to item number 5, my lord, I have this petitioner has filed one affidavit yesterday. Now, my lord, may I pray to list this matter day after tomorrow, my lord, along with the affidavit.
Our file will go. My file will reply. We have filed our affidavit, Your Lordship.
I am for the petitioner, my lord. I have filed one affidavit yesterday. This is, my lord, regarding attendance of the petitioner. Just she attended the classes for 10 years. In fact, it is 19 years she has attended classes, my lord. Now, if it is, this affidavit comes up, Your Lordship may come up at 2 p.m. also.
Some other day.
Day after tomorrow, always. Affidavit filed yesterday. Petitioner. Yesterday, obliged.
Later.
Mother, that 2023 matter, my lord. Matter relating to non-payment of salary, my lord. So, my lord, matter may be listed next date. For admission, my lord, next week.
Admission matter, my lord. Pensionary benefit, my lord.
My lord, registry.
Before the registry. Before the registry, my lord.
Registry.
My lord.
May I please, Your Lordship? Lordship, with due consent from the other side, I beg to mention item number 11 of today's list, Lordship. We appear for respondent number 4 to 10, the college authorities, Lordship. May I pray this matter may be listed after 3 weeks? Lordship, there are some subsequent development which we want to bring through an affidavit on record, Lordship. Yes, I am the respondent. 4 to 10, college authority, Lordship. I have taken consent from the petitioner. I have taken consent, Lordship. Yes, Lordship. In the month of June, we have filed our affidavit. An affidavit in reply has also been filed. A. Chakravarti. Four to 10. After 3 weeks, any day, Lordship. Obliged, Lordship.
May I please, Your Lordship? Lordship, I'm praying for listing of a writ petition matter pertaining to non-payment of retirement benefits for orders. No, Lordship, for orders.
I'm seeking listing, Your Lordship. I have already approached before the registry, Your Lordship, for listing this matter, but it has not been listed. On several occasions, Your Lordship, I have approached Your Lordship, therefore. By way of application, Your Lordship.
Please, Your Lordship, with the consent of the other side, Your Lordship, I will to mention item number 18 to 25, Your Lordship. 18 to 25.
19.
Oh, sorry, 19, Your
19.
Lordship. 19, Your Lordship. I'm appearing for the secondary department, Your Lordship. Lordship, my senior colleague is not available today, Your Lordship. NJ Khatania, Your Lordship. Yes. Yes, Your Lordship. Sleep has also been given yesterday, Your Lordship, a mention. Sorry, Your Lordship, I don't have him.
Sorry.
My microphone was off. What are these, what is the subject matter?
Yeah, Lordship, I'm sorry, I won't be able to say, Your Lordship, because I don't have any knowledge regarding the matter.
Then why do you mention without knowing what is the subject?
Lordship,
Board
because
may like to know also. Isn't it? Simply will adjourn like that. These are 2019 matters, you see, 16 also.
yes, Your Lordship.
There has to be a very good reason for adjournment. Just because he is not there, somebody else should appear then.
Only for today, Your Lordship. Then.
See, you're causing inconvenience for other cases. People are waiting for their cases to be listed. And when your case is listed, you adjourn it and you seek another date. Mr. N.J. Khatonia, Learned Counsel for the Secondary Education Department, who is set to appear before the respondent's concern, is said to have some personal inconvenience to appear before the court today. It is also submitted that consent of the counsel for the petitioners have also been taken. As prayed for, matter stands adjourned. For
today, Your Lordship.
huh?
For the day, Your Lordship.
For the day only.
Yes, Your Lordship.
Adjourned for the day. One more line. Since these matters pertain to the year 2016 to 2019, the parties are advised not to seek adjournment when the matter is listed next. Yes.
Obliged, Lordship.
For orders, item 15.
On the last occasion, there is a direction of this honorable court for taking steps by way of Dasti service. I have taken steps, Lordship, and accordingly I file my affidavit enclosing the relevant copy of the notice with regard to the received by the private respondent number 5, Lordship. So the service is otherwise complete.
Where is the affidavit?
Lordship.
TN4 is there.
3 and 4 services complete, Lordship. They
I
have
know,
got,
but where is 10? Where is 5?
5 I filed my affidavit, Lordship. Probably it does not come to record.
Flag B. Where is flag B? Kim, just find out any flag B in the second file. Oh, it's here, flag B. But this flag B is regarding respondent numbers 3 and 4.
No, Lordship, I filed my affidavit. I filed my affidavit, Lordship. Probably it has not come to record, Lordship. Then Lordship may take up the matter at 2 or at, Lordship, I will try to bring that particular affidavit, Lordship.
Who is the respondent number 5?
Lordship, respondent number 5 is the selected candidate, Lordship.
Name.
Atanu Nath, Lordship.
Affidavit is here.
Yes, Lordship.
But you have adopted the copy and paste system. Your nomenclature says additional affidavit filed by the petitioner with regard to service of notice upon respondent numbers 3 and 4.
Oh, Lordship. I'm sorry for that.
When I see the annexure, it is respondent number 5.
5. I'm sorry, Lordship.
This has caused the confusion. Office note dated 22/10/2025 indicates that petitioner has filed an affidavit with regard to service of notice upon respondent number 5 by way of Dasti. Full stop. Although the nomenclature of the affidavit is not correct, but Upon perusal of the contents of the affidavit, notice is declared to be complete upon respondent number 5. Stop. Now what?
Lordship, this matter may come up for admission, Lordship, in the next
Let the
week.
matter be listed for admission after 2 weeks
So can a date be fixed, Lordship?
on a date to be fixed by the registrar.
So it is very difficult to fix the date, Lordship, because on the
Let-
last occasion also I have to make a mention for listing. Because
They
on
will
2-3
fix it.
occasions I have filed application for listing, it was not listed.
What is the urgency?
Lordship, this selection is there, Lordship, the petitioner is hanging for last 3 years, Lordship, 2022 matter, Lordship.
Give a date after 3 weeks. On so and so, okay?
Obliged, Lordship.
16.
May I please, Your Lordship? Well, kindly peruse the order dated, Lordship, 17/10/2025, Lordship order, Lordship. Last 2 occasion there.
May it be pleases you, Lordship. One filing number is there. We have filed we will be filing our review petition, Your Lordship. Filing number given, Your Lordship, 12412. That may take, Your Lordship, that this similar matter will become, Your Lordship, on 4th.
You have filed or you will be filing?
Already filed, Your Lordship. Filing number provided, Your Lordship, 12412/2025.
My
On
Lord,
4/11. Cited আহিব বুলি ক'লে।
then my Lordship may take the petition along with the review case. Because my Lord petitioner is my Lord, in the verge of my Lord retirement. Otherwise, my Lord, the case will be become infructuous. So that my Lord result is required, Lordship. Either anyway, Lordship. So take the contempt case along with the review case because parties are the same, Lordship. We will repeat and.
Filing number is 12412
4/12
of 2025.
2025.
When is it going to be listed?
4th
On
November.
4th November.
November. 4/11/25.
Ms. P. Das Lanet, SC Secondary Education submits that review petition has been filed against the judgment and order dated 13/6/2024, passed in WPC number 426 of 2024, under filing number 12412 of 2025, and further submits that the same is likely to be listed on 4th of November 2025. Stop in view of above. Let this matter be listed on 4th of November 2025, along with the said review petition.
Deeply obliged.
Deeply obliged.
28 of the supply list.
May it please.
Are you sure? Where's Ms. P. Das? Ms. P. Das, kindly check up your review petition.
Yes, Your Lordship.
I've been told that it is lying defective.
Already, mention has allowed, Your Lordship, for 4/11.
It is lying defective, so just have a look, get it checked.
Yes, Your Lordship.
If it's defective, rectify it so
correct.
that the matter can be listed on that
Lord,
day.
Lord, Lord.
Yes, Your.
All
We
right.
will correct it. Thank you.
Effective of-
Oh,
Item 28.
May it pleases, my lord. My lord, we have received our instructions in this matter, my lord. We'd like to bring it on record, my lord.
Just a minute. This is regarding that transfer.
yes, Lordship.
What is your instruction?
My lord, we have received a copy of Service Regulation and Financial Regulations 2003 of SSA, my lord. Here our instruction says that a member of service engaged either on contractual basis or on deputation attachment shall be liable to be posted anywhere within the state of Assam or in any other department of government, corporate body, society in the affairs of which the mission may be interested. And in such cases, the member shall have no option against such posting or transfer, my lord.
So that's okay.
Yes, my lord. They have,
So far as transferability, there's no problem. Only problem here is that before, just within 1 year, again you have shifted him. This is their grievance.
And that too back to the same position
Ah,
and same place, Your Worship.
my lord,
so that instruction. you
Let them
can,
file
my lord, within 2 days, we can get this instruction only, my lord. Within-
No, that instruction is okay. You can
Hmm.
transfer. I don't think he has a problem with that. He may go anywhere. Only problem is that quick succession. It was taken out, again put back
My lord.
within 1 year.
Yes, my lord.
So that instruction you got to have.
Then I'm seeking more time for that instruction, my lord. Detailed instruction.
You take instruction, interim will continue. Your good name?
H. Borwa, my lord.
Mr. H. Borwa, Learned Counsel for the,
On behalf of Mr. B. Gogoi, my lord.
1 and 2 and 3 over.
B. Gogoi appeared for whom?
SSA, my lord.
2 and 3.
2 and 3,
Appearing
my
for
lord.
SSA respondent submits that he has received some instructions, but the same is not complete and prays for further time. Stop accordingly. Further, how much time? A week's time is granted
My lord.
to obtain instructions. Interim order passed earlier shall continue till the next date of listing.
Much obliged.
Obliged, my lord.
For admission, item numbers 1, 2, and 3.
No, see, before my learned sin starts,
Hmm.
see, I was directed to produce the original records as well as file affidavit.
Hmm.
Lordship, I required some time because Lordship, there was a confusion in the university with regard to registrar. On 25th, interview was conducted and new registrar is joined. Lordship, I pray that if my learned friend has done the object, maybe fixed on 6th or 7th of November. By that time, I'll obtain the original record as well as a file affidavit.
My lord, there are,
Very, very briefly, what is the matter regarding?
my lord, there are 3 writ petitions filed, my lord, in
Yes.
succession. First is, my lord, regarding challenge to the removal of the petitioner. He was a professor of Assam University. He was removed from 3 key posts. One is the dean, and the other is the, my lord, nodal officer. And-
From the post, not from the university,
Not from the university.
From the
Those
post.
posts were taken away from him.
taken away from you.
He remained a, my lord, professor. Then, my lord, the first writ petition was filed.
Hmm.
And immediately thereafter, he was placed under suspension.
Hmm.
That suspension order has been challenged in the second writ petition. And thereafter, my lord, the proceeding has been initiated. DP has been initiated there, my lord. I asked for certain documents. Those documents are not supplied to me.
Hmm.
And that is why, my lord, the third writ petition was filed. Now, my lord, in all these 3 writ petitions, only one affidavit has been filed in the, my lord, suspension matter.
Hmm.
I'll implore that your lordship will take up the, my lord, the suspension matter today. And maybe the other 2 matters can be taken up because, my lord, this can be segregated that way.
One is suspension, the other matters are regarding taking away the key post.
Key posts, and the third matter is regarding the supply of documents that I required for filing my written statement.
Okay, that documents have been denied to you.
That has been denied. Some documents have been provided and some have not been provided as yet, my lord, and they wanted to file an affidavit giving reasons why, my lord, they are withholding certain documents. So therefore, my lord, perhaps your lordship may take up the suspension matter at least today, my lord. I was placed under suspension in August 2022. More than 3 years have passed by.
Lordship, on
See, Mr. Chaudhary, that would be, that can be done, no doubt. But since the entire matter pertains to a person, if we can sort of, like take up the matter at one go, it would have been more preferable. And Mr. Kessi Kayal has some difficulty regarding records,
yes,
only records, nothing else.
And an affidavit.
affidavit.
Which affidavit, in which case?
Lordship, they have filed one affidavit, additional affidavit in that third writ
In
petition
the third writ petition,
That is regarding
regarding
the supply of documents.
non-supply of documents.
non-supply of documents.
Their contention.
That you want to respond.
No. Lordship may fix on 6th, I'll, by that time, I'll produce an original record and since the Lordship has expressed that all the matters we decide together, that will be, I think, my learned friend also not.
No, this is subject to what you all say. I'm just saying that because end of the day, the burden is upon the court to write something.
My lord.
So if you all can do it at one go, it's more preferable.
On 6th, Lordship,
6th is what?
has,
It's a Thursday, my
The
lord.
hearing date.
yes,
It's a hearing,
Mr. Chaudhary,
my lord.
although Mr. M.K. Chaudhary, Learned Senior Counsel for the petition is ready for hearing, Mr. S.C. Kayal, Learned Standing Counsel, Sam University, submits that he may be given some time to file a response to the writ petition by which the petitioner has alleged that supply of documents has been denied to him. To stop, he further submits that he needs time for production of the relevant records as well. Next para, as agreed to by the parties, let the matter be listed on 6th of November 2025
My lord, one observation, my lord, the
For-
records may positively be
for
produced.
admission hearing.
We will put it.
Mr. S.C. Kyal, learned standing counsel, Assam University shall produce the records positively on that day.
Not,
Highly
Not-
obliged.
not sure.
Item 4.
Well, can we pass over for timing, Malad? Senior is coming, Malad. Pass over timing, Malad.
Who's for the other side? You are there.
For timing, Malad.
Matter can be heard? All right, pass over for the timing.
All right.
Item 6.
Lordship, I have a very humble prayer, Lordship. I was not keeping well. Let this matter come up the day after tomorrow, Lordship. I could not go through it completely. I was not keeping well. On Thursday, Lordship.
Just find out Thursday, what is the situation? Hmm. Hmm. Doesn't matter. We can have it, I think. Ms. S. Parveen, learned counsel for the petitioner, submits that she is not feeling well today and prays that matter be taken up on Thursday. Thursday is what, 30? Speed as learned SC secondary has no objection to the prayer in view of above list on Thursday.
Highly obliged, Lordship.
And for respondent three,
I have recorded.
deeply obliged.
7.
Maybe Lordship.
Yes,
My lord, this matter pertain regarding the, my lord, suspension, my lord.
suspension.
Yes, my lord, the petitioner service was not
Hmm.
regular. He was,
How long you have been suspended?
my lord, the suspend, my lord, in the year 2015, but thereafter he was reinstated, my lord.
Hmm.
But his service was not regularized, my lord. Initially, the petitioner was appointed as a examiner of examination center, my lord. And particular day he was absent, but in my reply, he was the absent, my lord, due to his illness, my lord. Thereafter, my lord, 2025, petitioner suspension on that ground, my lord. My lord, that is 29, my lord, the suspension order, my lord. Page 29.
Just a minute. How many respondents are there?
Respondent, my lord, 4 respondent here, my lord.
Who's respondent number 4?
Respondent number 4, my lord, deputy headmaster of the schools, my lord.
Notice is served?
Notice served, my lord. Affidavit government inspector of school affidavit file, my lord.
Yes, who's appearing? Government?
I'm appearing for secondary education, your lordship,
Yes.
respondent number 1, 2, and 3.
Are you ready?
Already our affidavit already filed.
Are you ready?
Yes, your lordship.
All right. Yes.
So, my lord, but you will also kindly see the idea what I am, that will make everything clear, my lord.
Which earlier order?
Yes. You can have page 31, your lost kindness one. Page 31,
Page 31?
my lord. Oh, sorry.
This is the second round.
It is third round.
Okay, let's go from the first. Let's see the first round.
First round, my lord.
Hmm.
First round is what was? Page 30. Suspension set aside and asked to reinstated one. Page 31. 31 starts, my lord. Thirty-five is the operative part.
Okay, first
Then,
round read.
then contempt filed.
Contempt.
Thereafter, during the pendency of contempt, page 38 comes, my lord, the reinstatement order. Oh, sorry, page 37.
37 is a reinstatement.
Yes. So contempt would go, man. Closed.
Then
Then page 39, I filed representation for areas. As well give the ROP, my lord, that's page 39, 40. Representation. Not disposed, so then again, second round, 41, page 41. Your loss will find page 42. That is second round.
so what had happened in the meantime was that some proceeding was drawn. It was not concluded.
Not concluded.
Court said that you concluded within 2 months.
Yes, thereafter.
Failing which, it will deem that authorities are not keen to proceed. Okay.
Yes, thereafter your loss will find, so called page 44.
Mm.
Instead of matter complying within regular time, they issue shock cause notice. It is simply delaying my lord. That is. Then I reply,
What is the date of this show cause?
show cause is, this is last page on your loss will find. It is page 45. Huh?
Date.
Both places are gone. Where is the vote? The reference. No. Date what is page 44, 45.
There's no date.
Only reference is there. That's for November. This is letter is also November, my lord. Our reply.
No, direction of the court was dated 25th of November.
Yes,
Then show cause is also November,
November.
but no date.
No date.
It was after the court's order or before the court's order?
Yes. Court order is 25/11/19.
Then show cause is which date?
So cause is, it is a 19, but date is not a reference is 4th November simple. Man.
Anyway, let's proceed.
Anyway, then we
Thereafter.
replied.
Hmm.
Our reply is 4 December. Page 46.
See, you said, "Yeah, I received your letter from our headmaster on 26 November.
26 November.
Ah.
Right.
So after the court's
So
order.
after that, madam, after court order.
Then
Then your lord will find second representation also submitted. Then again, my lord, your page 48. 24th April 21, clear for regularization of period of suspension, page 48. Nothing.
now after the show cause and the reply, what happened?
Huh?
After show
Till
cause
today,
was given to
till
you,
today, nothing, no conclusion. Then you have to kindly page
proceeding has not concluded.
not concluded. And their allegation, they have in the affidavit say that I have not attended. I have submitted all the reply, etc., everything on the record.
We have mentioned it here, in.
Ms. P. Das, you'll get your chance. Let the senior counsel argue. 24th April
Yes.
is your letter
My 20
for regularization.
for regularization. 21. Suspension period as well as the my lord payment as per RP rules. Conclusion, madam. Payment of month is stuck on the basis of the existing RP rules 27, bottom, page 48, bottom. তোমার নাম কই? কোথাও বলতেছেন?
This is rather a mixture of representation. You are saying that you joined back service as per reinstatement order
Yes,
and you have not received arrear salary
yes.
for the suspension period.
Plus ROP minor as per existing.
And
law.
you are saying I am still being given monthly salary in the earlier scale of
Earlier,
pay.
And for that minor, your loss will find I am getting last page 51. Pay slip your loss.
Particular thing you see.
Yes,
Now, with regard to your suspension period, what your entitlement would be the subsistence allowance.
that I got.
Now, ultimately, if the inquiry
Yes,
concludes in your favor,
right.
then perhaps that period will have to be regularized. And for that regularization, whatever pay is entitled to you will be given to you. That is one thing.
Right.
Now, if the inquiry ends, you'll get is only the subsistence allowance, nothing more.
No, if inquiry might not come
Now-
to conclusion, then
Coming to the other pay scale as per ROP,
but they are not paying that also because of this minor. That though they have not stated because of this, we are not paying them because of this minor. And you kindly see page 43 minor. What is the order of this honorable court? Page 43.
no, that is to complete within 2 months.
No, that accordingly the aforesaid period of suspension shall be regularized and be treated as on duty. And all the consequential benefits, including salary, be given to the petitioner by treating this period to be in regular service after deducting the suspension allowance over there. Page 43.
Okay. So this was passed.
That's right, 43. Nothing has been done. So that order is there. They are bound to pay my order because they have not challenged this order.
And what have you done? You have not filed any application
Yes,
for violation of this order.
no, that contempt file, but I have approved my lord and thereafter
That
again.
was earlier.
Yes. Earlier.
Because
Thereafter, my-
reinstatement was not
then
coming
they
into
issued,
contempt.
they issued show cause notice, my lord.
Hmm.
Instead of complying, issue show cause notice. That is what I am saying. my lord.
So as on today, what is this situation? Why have you filed this writ petition now?
This couldn't file because they are neither concluding, but I am entitled to, you'll consider my prayer, my lord.
Okay, now you come to page 49.
Yes,
This is what the second writ petition.
yes. That was because of reason. So today it is the fourth minor round of litigation.
Second or third?
That is the third, page 50. That is a Udgol, my lord. Because some differences from some RDR category was engaged, my lord. That was Udgol,
Or it was withdrawn?
Udgol, my lord. Then kindly see my lord, page 40. Page 52, no, 50, 51.
So now let us come to your prayer now. What are you
Yes,
seeking?
yes,
This writ petition.
Exactly. Yes,
Regularization of suspension period,
Yes.
then
There is suspension period from 20 so and so by treating the same as on duty to give that already finding of the this honorable court. Given effect by this court or court order dated 25. And as to why direction should be issued direct correspondent to give all consequential benefits and the benefit of that might we have reiterated our court's order. That
Yes.
with effect from so also at old pay till auto and thereafter from 1/4/2016. That is the my ROP, present ROP came into effect till regularization at revised pay so and so. So that I am entitled earlier one while.
So what has happened as on today that the parliament proceeding has not concluded
Not concluded.
and you are enjoying pay scale
No,
in the old rate,
earlier old one.
in the old rate,
Old-
as per the
old
old rate.
And that's why I'm getting about 50% less, madam. Page 51, just have a look at page 51, madam. The teacher, madam, how you will maintain your loss.
What is the position you're holding?
I'm assistant teacher of a high school.
Assistant teacher of a high school,
Yes.
teaching Arabic.
Arabic. Allegation was that madam, he had some duty for evaluation purpose, madam. And he remained absent 1 day or 2 days, madam, that. Then page 51, you will kindly say 3, madam, serial number 3,
Page 51.
page 51.
Yes.
Okay. Serial number 3, my lord, you can you say right side, 38,220. My colleagues are getting on the same 81,000. That is on 27/10/22.
This is as per the ROP.
Yes,
ROP of which year?
they are getting it is with effect from
2017.
yes, no, with the 16 with effect from 31st 1/4 matter, sorry. 1/4/66 came into effect. There in pair percentage there, man. Benefit of area salary with effect from so at the old pay scale till 31st March 16 and thereafter from 1/4/16 came into till the regularization.
Okay, what kind of school is this? This is a high school,
High school, provincial high school. Man.
provincialized high
Yes,
school.
yes, provincial high school.
So that is the sum and substance of
Province
it.
substance, man. Simple prayer matter to implement the order of the Honorable Court, man. Of 25/11/19. Now they are saying, madam, that I am not appearing in the hearing, etc. This thing they are saying, madam. And your lordship can see so-called notice reply I have given, I have annexed also, madam. But let them conclude at least, my lord. In the meantime, my entitlement, my lord, is there. So far salary is concerned. Because I am serving.
Okay, so let me ask Ms. Fida.
Madam,
Yes.
I think, my lord,
Yes,
it is
you got
clear,
it.
madam.
Your
That is clear.
In our affidavit in opposition, I would like to take you straight to page 80, paragraph 4 of our affidavit in opposition.
Yes.
It was said that the answering deponent humbly begs to state that the petitioner was appointed as examiner of HSLC examination Arabics, and he was found unauthorized absence from dated 13/4/2015 to 19/4/2015 from his duty at Rongia Higher Secondary School, where he was deputed. The inspector of his school on his evaluation zone visit on 19/4/2015 and found the petitioner absent without any prior permission and information, and thus suspended on 20/4/2015 by issuing one later, your lordship, suspension order that annexed as annexure 1. I have annexed it at page 86 of my affidavit in opposition.
Hmm.
Page 86. Order was issued on 20th April 2015. It was in the order, your lordship, it was written, I would like to read it. Mrs. Manumati Deka, assistant teacher of Bezera Girls High School, and Mohammad Zakir Hussain, assistant teacher Arabics of Madhupuchi Ansolik Girls High School, are found absent in evaluation duty today, dated 19/4/2015, during my evaluation zone visit at Rongia HS School.
Ms. Pidas, regarding that, there's no dispute.
Yes, Your Lordship.
Only thing is that why are you not concluding the proceeding?
Your Lordship, that also I have stated that.
Where?
Paragraph 4, page 80 itself. There is numerous of Your Lordship show cause notice was issued against him from 2015 and again reissued in the year 2016, then 2019, then to 2023. But the concerned headmaster of the said informed that the petitioner Zakir Hussain, which is the present petitioner, denied to accept the same, and the petitioner never replied any show cause notices. Thereafter, the departmental proceeding was drawn against the petitioner, present petitioner, that is Zakir Hussain, as per rules, whereas the petitioner denied to accept the communication to the office. As such, hearing was conducted, although petitioner did not attend. In continuation to that, page 81, I'd like to read it. The hearing before the concerned authorities and headmaster report was prepared while issuing one later dated, which was issued on 28/12/2019. Again, I have annexed it as annexure 2.
When you come to Annexure 6, page 96.
Yes, Your Lordship.
Yes.
This was the last time, Your Lordship.
After this, anything happened?
Your Lordship, I would like to take it because as per my concerned knowledge, Your Lordship, he did not turned off, Your Lordship.
Okay.
So, Your Lordship, the departmental is still pending and it was not concluded because he was kept on denying. Every time he denied it. As per I have received the instruction from the department, concerned department. So, Your Lordship, and also, Your Lordship, there is 2 times, Your Lordship, paragraph.
So to
7.
cut the matter short, we'll direct him to appear and
Yes, Your
then you conclude the proceeding.
Yes, Your Lordship.
Matter ends there.
Yes, Your Lordship.
Then about salary part, other
Sir,
part, my lord.
That would come
That is,
later
that
on,
is,
Your
this is
Lordship.
something, because this is pending matter. I am
That
now-
come later on, Your Lordship,
Oh.
because he did not appear turned on,
That is
Your
another thing,
Lordship.
madam. I am till today, I am working. It is my entitlement, madam.
Got suspicious, Your Lordship, during his
Let them conclude, let them give hand,
Insincerity.
whatever they do it, madam. That will, law will take its own course, madam. But that they cannot deprive me of
And
my
your-
salary.
And Your Lordship, pertaining to that, Your Lordship, his paragraph 10, also, Your Lordship, I have mentioned it in page 83 of my affidavit in opposition. Paragraph 83. Paragraph 10, that the answer, I would like to read it, Your Lordship. That the answering deponent humbly begs to state that the enrollment in Arabic in the said school is nil from year 1995 till 2004. In the year 2005 to 2012, there is a total strength of the students, Your Lordship, appeared only 7
All
number
right,
of students.
is this
And
one of
third
the,
division.
no, is this one of the charge?
No, Your
Then-
Lordship. So
That's what my lord.
These are here and there. It's neither here nor there. Main charge is his absence from duty
Yes.
for 4 days without authority, without taking permission. That much only. You complete that.
Yes.
Heard Mr. H.R.A. Chaudhary, Learned Senior Counsel, assisted by Mr. S. H. Ali for the petitioner and Ms. P. Das, Learned Standing Counsel, Secondary Education Department for respondent numbers
1, 2, and 3.
1, 2, and 3. Anyone for the headmaster? None appears for the headmaster despite service of notice. Stop. Having regard to the nature of the grievance projected by the petitioner, the writ petition is taken up for disposal at this stage. Stop. This is the 4th time the petition is before this court. Stop. The first writ petition being WPC number 7143 of 2016. Was filed by the petitioner with a grievance that he had been kept under prolonged suspension without any review. Stop this court by referring to the apex court decision rendered in Ajoy Kumar Chaudhary versus Union of India and others. Reported in 2015, 7 SCC 291, disposed of the writ petition by setting aside the order dated 24/2015, by which the petitioner was placed under suspension. Stop. It was, however, the respondent authorities would be at liberty to proceed with the petitioner, against the petitioner, in accordance with law. Stop. Reinstatement of the petitioner was persuaded after the writ petitioner filed a contempt petition. Stop. He was reinstated by order dated 6/6/2018. Stop. The petitioner then submitted various representation for regularization of his suspension period, that is, with effect from 24/2015 to 6/6/2018, and for payment of his area salaries as per the existing rate of pay. Stop. Since his representations were not considered and disposed of, the petitioner initiated his writ petition, his second writ petition, that is WPC number 2788 of 2019. Which was then disposed of via order dated 25/11/2019. By directing the respondent authorities to conclude the disciplinary proceedings if they wish to hold the same against the petitioner within a period of 2 months, failing which it would be deemed that they are not keen to proceed against the petitioner. Stop. It was further directed that the period of suspension of the petitioner should be regularized and be treated as on duty, and all consequential benefits, including salary, be given to the petitioner by treating the said period to be a regular service after deducting the suspension allowance if already paid.
My humble prayer is that your lordship kindly, it may directed your lordship that petitioner may your lordship attend your lordship that.
Why are you disturbing the court? I'm narrating the facts and dictating. When I come to the conclusion part, you may inform the court. As of now, I'm dictating the facts. Next para. Pursuant thereto, the respondent authority concerned issued a show cause notice dated November 2019 to the petitioner. By incorporating 3 charges Stop. The said show cause notice presumably was received by the petitioner on 26/11/2019, which can be seen from his reply to the show cause notice dated 4/12/2019. Full stop. In his reply, the petitioner stated that he denied all the three charges leveled against him. So after the petitioner submitted the aforesaid reply, since no further steps was taken, the petitioner on 24/4/2021 submitted his application for regularization of the suspension period and also for grant of his arrear salary, including payment of monthly salary as per the existing scale of pay, to the Inspector of Schools, Kamrup District Circle, Amingaon. Stop. Since no further action was taken, the petitioner filed his third writ petition, that is WPC number 4467 of 2021, which however was withdrawn on 12/12/2022 with liberty to file afresh. Stop. Subsequently, the petitioner on 18/5/2023 seeking regularization of his suspension period with effect from 24/2015 to 6/6/2018. And to pay consequential benefits, including area salary, with effect from 24/2015 as per the old pay scale till 31/3/2016, and thereafter with effect from 1/4/2016 as per the revision of pay rules 2017. Next para. Mr. H.R.A. Chowdhury, learned senior counsel, appearing for the petitioner, submits that the departmental proceeding drawn against the petitioner has not culminated by passing appropriate order. To stop, the period of his suspension has also not been regularized, and the enhanced scale of pay as per the ROP referring to the order dated 25/11/2019, passed in WPC number 2788 of 2019. The learned senior counsel submits that court had clearly directed that the suspension period of the petitioner should be regularized and should be treated as on duty, and all consequential benefits, including salary, be given to him by treating the said period as regular service after deducting subsistence allowance. To stop, he submits that the said order has attained its finality because the respondents have not questioned the same by filing appropriate process. Stop. Therefore, they are duty bound to comply with the same, and for which necessary direction will be passed to the respondents. Next para. Ms. P. Das Lanet, Standing Counsel, Secondary Education Department, on the other hand, submits that the petitioner was unauthorizedly absent from 13/4/2015 to 19/4/2015, despite having been appointed as an examiner of the HSLC examination (Arabics) at Rangia Higher Secondary School. To stop, the Inspector of Schools, on making a visit to the place on 19/4/2015, found the petitioner to be unauthorizedly absent and suspended him on 20/4/2015. To stop, she submits that although the petitioner was issued show cause notice in the year 2015, 2016, 2019, and 2023, but he refused to accept the same. Stop. He was also summoned for personal hearing on 3/6/2023 at 1 p.m. to appear before the Inspector of Schools, Kamrup District Circle. But again, the petitioner failed to appear, failed to appear. Stop. Such being the position, the respondent authorities are not in a position to complete the proceedings drawn against the petitioner for want of cooperation from him. All right. Now you tell me, what do you want to say?
Your Lordship, as he did not turn off your Lordship to attend this your Lordship meeting, your Lordship, one direction may be given, your Lordship, he should be present on the next. Sure. It is your Lordship.
When you want to suggest a date, Mr. Chaudhary, what do you say?
I'm ready anytime, madam. I can, because earlier also I submitted anytime your lordship fix, madam. Only my other part, my your lordship will consider. That's so far the proceeding is concerned, I'm ready, madam, anytime your lordship. I can appear, madam, no problem. Your lordship may fix a date also, madam.
Next para, considering the above projection made by the parties, it only appears that although the petitioner is serving as Arabic teacher in his school, but the proceeding drawn against him remains unconcluded. Stop. It may, however, be seen that the suspension order
Suspended order is
Dated.
29. 29, page 29.
24/2015 had already been set aside by this court. White order dated 5/6/2017 passed in WPC number 7143 of 2016. Stop. Further, this court, white order dated 25/11/2019 had also directed regularization of the suspension period by treating the same as on duty with consequential benefits, including salary. White order dated 25/11/2019 passed in WPC number 2788 of 2019. Stop. No materials have been brought before this court to show that the, say, two directions have been interfered with by a larger bench or the same has been recalled at any point of time. Stop. Such being the case, it would not be open for the respondent authorities concerned to not implement the same. Stop. In other words, the period of suspension of the petitioner should be regularized and be treated as on duty for all purposes. Stop. The petitioner should also be given his salary for the aforesaid period. Subsistence allowance. Stop. Further, the respondents would also have to give the petitioner his entitled salary as per the revised rules concerned. Such an exercise be completed within a period of 3 months from the date of receipt of a certified copy of this order, and pending finalization of the proceeding, which was subsequently initiated, write the show cause notice dated nil November 2019, bracket annexure 10, which was responded to by the petitioner by filing a reply to the show cause notice on 4/12/2019, bracket annexure 11. Since it has been alleged that the petitioner has failed to cooperate with the proceeding brought against him, this court deems it proper to direct the petitioner to appear before the which respondent?
Yes.
I see.
Inspector of
Respondent
schools.
number 3,
Inspector of schools.
Was it schools?
KDC,
Go ahead.
KDC, Amingaon, Guwahati 31.
Page 5.
Kamrup District Circle, Amingaon. Bracket respondent number 3. On tenth of November,
You'll go along with this writ petition and extracts, etc. my lord. That will be.
10th of November 2025. Along with a certified copy of this order. Whereafter, the said authority shall proceed with the proceedings in accordance with law and bring the same into its logical conclusion.
Within a period of some.
As expeditiously as possible and at any rate within a period of 3 months from the date of the appearance of the petitioner. Anything else?
Obliged.
With the above observation and direction, the writ petition stands disposed of.
Deeply obliged.
Mr. Chaudhary, you please advise your client
Madam,
also to cooperate.
I think, madam, to my instruction.
Let him cooperate.
Yes, my sir, it is his interest, my.
It is only for his interest.
Right, exactly. Obliged.
I've made.
May it please your lordship.
Yes.
Well, this matter involves in a very narrow compass. It's the impugn order says that there is no provision in so far this case is concerned for condonation of delay, as for condonation of age. But there is this office memorandum of the government, which your lordship has dealt with in one case, where there is a provision for condonation of age. Your lordship will find
For the purpose of?
for the purpose of provincializing the services of the petitioner, who has been working since 4/7/2008.
Is there a limit for provincialization? Age limit?
Up to 38. Up to 38 years.
38 years.
Yes. And
If you are beyond 38 years, you cannot be provincialized.
then, there's a office memorandum at page 44 of the writ petition. Your lordship will find annexure 19, which gives the.
Mr. P. Das, you are there? Mr. Das, are you appearing?
Yes, I'll be appearing.
For which respondent?
I'll be appearing for
1 and 2.
1 and 2, my lord. My lord, in this
3 and
case,
4 has already been deemed to have been served.
we have to file affidavit, my lord, in this case.
Huh?
We need to file affidavit.
You need to file affidavit.
It's only on a point of law, my lord, which your lordship has already dealt with in one of the cases.
1 and 2 you are representing,
Yes,
and 3 and 4 notice is served.
Yes,
Governing body and principal.
principal. 3 and 4 is deemed to have been served. This office memorandum, your lordship has dealt with in one of the cases.
My lord, here in this case, the petitioner is challenging the rejection order by the principal, my lord, age condonation, whereas the proper authority is the commissioner and secretary, my lord. The competent authority to condone the age.
Your lordship will see the impugn order at page at 43.
By the principal.
Yes.
There's no provision for condoning. Has been informed like that. And where is that provision which says that 38 years?
Well, 44 is the office memorandum, my lord.
44.
44.
It's general rules for relaxation of age.
Yes, madam.
No, I wanted to know what is the requirement? You have to be under this age
Oh.
to be relaxed.
Hey, no.
I mean, to be provincialized.
Yes, madam. Just a moment. Ma'am.
How old are you?
40. And I have been serving in this institution from 2008. And all the proposals, if I take your lordships to all the annexures, it will be seen that this post was created just to regularize the post of the petitioner which she has been working. Yes, to show.
Office memorandum of 3/5/1951.
Yes, ma'am. That your lordship has dealt with in one of the cases. Of course, that is a case where prior to recruitment, here already I am working.
You're already working.
Yes.
Where is the notification office memorandum?
At last page at page 44. And this office memorandum has also been dealt with in one of the cases of this honorable court, my lord.
This has not gone any amendment or changes?
Is still holding the field.
Still holding the field.
Yes.
Mr. P. Das,
Mr.
you must have come across.
Yes, my lord. But
What
this is
is-
holding
what
the
is
field,
it?
my lord. There is no doubt, my lord. This is holding the field.
Huh?
But the thing is that, my lord, the competent authority to condemn the age is not the principal of the college, it is the secretary, my lord. Secretary of the department, head of the department, as per this page 44 also, my lord. The office
So can
competent-
we dispose it of by saying that the principal directed to the concerned authority, let them consider?
Or my lord,
Hmm.
there's two things, my lord.
Hmm.
Here, this general rule, my lord, says that condonation of age, relaxation of the age limit for recruitment, my lord, not for regularization.
Nevertheless, let him
recruitment-
consider, let him say so.
Yes, my lord.
No.
Recruitment, my lord, in my humble
No, no.
submission, my lord, the recruitment is
My lord.
once the post is created.
No.
As per rules.
Your lordship will have
Direct recruitment, my lord.
My learned friend probably has to go through this WBC number 7832.
Which paragraph?
Rubita Dekar's case.
Paragraph?
My lord. Paragraph number 24. 23, 24. Paragraph 24. 22, 24. At page 13. In this case, your lordship will find at paragraph 22, there the petitioner had worked only for 10 years. Here too, I have been working since 2008.
No, one thing, Mr. Das says that it's regarding recruitment.
Hmm.
So this order is also with,
No, your,
subject matter is also regarding recruitment.
the says WPC number 7832, that order, my lord.
Yes.
Paragraph number 22, your lordship will.
No, before that, paragraph number 3, petitioners in both these two writ petitions were initially appointed contractuals under the establishment.
So they have been working.
Okay, they have been working, all
for
right.
10 years.
Initially appointed, okay.
Yes. Here too, I have been working more,
Hmm.
almost till today I'm working from 2008.
What has happened to this order? Has it been challenged?
No, no.
Not
I have
challenged.
not. Because this has been frequently, I have seen it being cited in different courts, my lord.
Hmm.
But what I propose, my lord, let the, he says the commissioner and secretary is the appropriate. Let him take a call on this and this petition can be disposed of. If we are aggrieved by any order passed, then we can come again. But keeping this matter pending because time is running out. my
That's
lord.
right.
Yes.
Mr. Das, can we do that?
Let us
No,
know.
let petitioner be filed one representation before the secretary, my lord, because before secretary, they have not approached the competent
No,
authority.
no, no, your lordship. Your lordship will see the annexure 17, that's page
That
42.
That is Minister of Education.
But he-
The head of, kindly see the page 44, my lord.
Which secretary? Secretary of
Higher Education Department.
Obligations. I think
They
you
will
should
decide.
file one. You file one, give you liberty to file.
But we have already filed.
You have filed before the principal
Yes, so one,
and the minister
yes.
and director.
Now your lordship will find you at page 38 also. Director.
Have you taken the ground that because of this OM?
My lord, this OM was also my lord, challenge. And my lord, there is another judgment of this honorable court which has upheld this 1951 OM. Thank you.
In your representation before the director, you have not mentioned about the OM.
No, no, and that's
Which is the relevant para?
just a moment. Page 40, your lordship will see the direction. In regard to the OM.
Hmm.
Yes, ma'am.
Page? Paragraph?
The operative paragraph is page, paragraph number 40 at page 407.
Hmm.
Then your lordship will. Because paragraph 28 deals with the OM, madam. Well, we are not shying away from it. If he says today is that we have approached the director, my lord, and your lordship will find even in the impugn order, it says that as per Director of Higher Education's letter.
So tell me, are you prepared to file one representation? Or you want to rely upon this director, the one which you have?
Now, your lordship will set aside this impugn order at page of 43 and direct
No.
us to approach the commissioner and secretary, my lord.
No, what is there to set aside?
Because your lordship will see that with reference to as per the DHE letter number, you hereby inform that there is no such provision for relaxation of upper age limit. That's fundamentally wrong, my lord, in terms of this three judgment of this honorable court.
What is the nature of your appointment? As what?
Assistant professor in a Hindi department.
Assistant Professor Hindi in Lalu College.
Yes, madam. Your lordship will find
This
that.
is a provincialized college?
Yes, yes. Your lordship will find that the proposal is already there.
at the time.
Oh, we'll pass a simple order. You file one precise, concise thing. And within a period of certain period. and-
There are two issues, my lord, actually. One is relaxation of age, one is, my lord, petitioner is seeking provincial, sorry, regularization, my lord. But as-
Regularization.
yeah, as per
Right,
rules, my
once,
lord,
once it is, because I have been prior to that, I have, so far the rules is concerned, that is not a problem. But it is only the upper age limit is being a hurdle. So we'll file a detailed representation. If necessary, we'll annex the judgments of this honorable court also in that representation. That's not a problem. And your lordship will
No,
find that.
what exactly are you seeking? Provincialization or regularization?
No, once my age is condoned,
Ah.
this post has been created to regularize my service only.
Oh.
So once this age is condoned, automatically the other things will fall into place, madam. Because
No relaxation of the age for the purpose of provincialization.
yes,
regularization.
once that is done, then the other things will fall into place. That's the only hurdle I have to cross now.
Okay, we'll dispose it up.
Yes, my lord, dispositive what to approach the proper authority, my lord, in terms of 151 OM.
That is the secretary. You only.
Yes,
told-
yes, yes.
So
Head of the
secretary, higher
Yeah.
education.
Yes, head of the department.
Even the director, when we had approached, he could have forwarded it to the competent authority. Now it's only I have to run from one desk to another. And your lordship will find at page 26.
Another thing is that as a you are an assistant professor.
Yes, ma'am.
Your representation should go to the director normally, isn't it?
Yes.
Normally, you don't address straight to the secretary like that.
No. My friend has said that's
Or-
why I'm.
or- My lord, may give
it's on-
me some time, I will file the affidavit, my lord, because
Affidavit saying what?
my lord, there's two issues, my lord, as I have already said, my lord. One is for relaxation of age, which.
See,
as-
Mr. Das, you understand, we are not adjudicating the matter.
Yes,
We're
sir.
saying that this is a provision. Kindly consider as per the provision, that's all.
That's it.
Whatever decision you want to take, you take.
Yes, ma'am.
Now, only question is whether he should file before the director or the secretary straight away.
Secretary, my lord.
Secretary. You know, otherwise the transaction of business rules or the CCS conduct rules and all that, normally not joint representation cannot be filed or a person cannot directly approach that authority.
Normally, he is the appellate
All
authority.
these things are there. So that is why I was asking you.
As per the
Therefore,
rule.
judgment, my lord, I don't remember this judgment. There, my lord, this honorable court has directed to approach the authority, or approach the, my lord, competent authority. That-
Anyway, the decision maker is the secretary,
Yes,
the government,
yes,
not a directorate.
not director.
Your lordship will also take care of now when there is an interim order protecting not to fill up the post. They will not take the call in the meantime when they take this decision. Will at least give me,
Okay.
because there is only a solitary post.
All right, heard Mr. B.D. Kowa, Learned Senior Counsel, assisted by Miss
JM,
J.
JM Kaur, Chotimala Kaur.
J. M. Kaur for the petitioner. And Mr. P. Das, Learned,
Yes, that's my lord.
Mr. S. Das, Learned
Standing
Standing Counsel, Secondary Education Department,
education.
Higher Education Department, for respondent numbers 1 and 2.
One and-
Stop. No one appears for respondent numbers 3 and 4, despite notice. Stop. Having regard to the grievance projected by the petitioner, the writ petition is taken up for disposal at this stage. Next para. This is the case of the petitioner that he has been appointed and working
Well,
as
I have given a list of dates separately. Your lordship can take. Assistant professor, ma'am.
assistant professor
Yes, ma'am. In Hindi.
in Hindi department at Lalu College since 4/7/2008.
Yes, sir. Appointment is 4/7, joining is 4/8.
Joining 4/8.
4/8. Appointment is 4/7.
Since 4/8/2008, okay? Pursuant to the appointment order issued on 4/7/2008. Stop. It is the case of the petitioner that having gathered enough experiences and having served in the aforesaid capacity ever since
4/8/2008.
her appointment,
Yes, madam.
her services have not been regularized till date, solely on account of the age bar. Stop. The application for relaxation of age submitted by the petitioner was responded to by the principal of the college by letter dated 22/7/2024 by stating that there is no provision for relaxation of upper age. Now, the learned senior counsel submits that the aforesaid rejection is fallacious in view of the fact that there is clearly a provision issued by the government by AAP.34/50/27 dated 3/5/1951 under the heading inverted comma open general rules for relaxation of age limits close bracket. Stop. Referring to the said provision, which is annexed as Annexure 19 to the writ petition from Mother Learned, senior counsel submits that in appropriate case, the state government can relax the age limit of persons who are appointed to civil services or civil posts in connection with the affairs of the state of Assam. Full stop. He submits that the said provision has been relied upon.
The first case is 2016 1 GLT, that is 2016, the Justice U Mia's case. Then, my lord, 2018, then your lordships is of 2022.
By this court. In a number of cases, and three cases among those cases are as follows, column dash. Number 1, Pranab Kumar Deka and others versus State of Assam and others. 2016 1 GLR 391. Number 2, order dated 26/2/2019, passed in WPC number 7832 of 2018, open bracket, Robita Deka versus State of Assam and 3 others. And number 3, order dated 13/10/2023, passed in WPC number 7151 of 2022. Open bracket, Bipul Das versus State of Assam and 3 others. Next para, the learned senior counsel submits that in view of the above position, the principal of the college ought to have forwarded the application of the petitioner before the appropriate authority for considering relaxation of his age in terms of the office memorandum.
My lord, I'm sorry to interrupt. Principal has forwarded, director has rejected.
Okay, instead of principal, you write director. Director ought to have, director of higher education
Higher education.
ought to have forwarded the same. What did I say? Forward the same. In the state government, appropriate authority in the state government for relaxation of so and so. We'll stop. Such steps having not been done, the learned senior counsel submits that the impugned communication dated
22/7.
22/7/2024 bracket annexure 18 should be set aside. And the respondents directed to consider the age relaxation of the petitioner in terms of the said provision. To stop to this submission, Mr. S. Das, learned standing counsel,
Higher education.
education, has no objection to the prayer. Accordingly, this writ petition is disposed of by directing the petitioner to file a fresh and concise representation before the Secretary to the Government of Assam, Higher Education Department, seeking relaxation of age by annexing all relevant supporting documents and authorities as may be advisable within a period of
2 weeks.
15 days from today. Upon the submission of the said representation, the Secretary, Higher Education Department shall consider the same and pass appropriate orders within a period of
My lord, 2 months, madam.
2 months.
Yes.
2 months from the date of the receipt of the representation, which shall be communicated to the petitioner as well.
My lord, there is a protection given by this honorable court not to fill up. That will continue, my lord.
What is the date?
Just a moment. First day only. I think there's a protection that not to fill up the post. Because this is a solitary post of Hindi teacher in that. Slim.
It is not there.
But also for a long back, your lordship will direct them that till such time, since he is still working in that post, till such time they will not fill up this post.
Okay, till
Communication now.
Till a decision is taken by the Secretary, Higher Education, as directed herein above. Till such time, the Secretary of Higher Education takes a decision as directed herein above. The post of Hindi teacher.
Assistant professor, Hindi
The
teacher.
post of assistant professor in the Department of Hindi
At Laluk College.
at Laluk College shall not be filled up.
Yes.
With the above observation and direction, the writ petition stands disposed of.
Your lordship may use assistant professor stroke lecturer because she has to be appointed.
Stroke lecturer.
We are obliged, your lordship.
Okay, we'll resume in 5 minutes. Then let's finish the admission matters.
Item number 4 was,
Mahanta.
time being, for the time being, it was passed over.
Can you wait for some time?
Sorry.
Let us complete the other matters.
Yes.
Once we are done with the other matters, we'll take up the timing.
And Lordship may take it up some other day.
Okay, when do you want it? Who's for the other side?
I am the principal of the, I'm the governing body and
Okay.
represent the field as well as principal, my lord.
Ah.
We have some difficulty due to, my lord, pending of this case, all students are suffering. Because of that, more than 5 years now, this was not filled up, already selected and forwarded for the governing to the approval of the higher authority. But till today, they don't have approved, my lord. Otherwise, entire students communities is suffering regarding that particular political science department, my lord. As
What,
day before
matter
last-
is simple. Matter is very simple, but government is raising a point which appears to be they are trying to make it complicated. Nothing else.
We have already given the, my lord, written argument also so many times. There is already times are as a father.
This was hard judgment reserved. But then ultimately.
Okay,
was-
it's up to you. You can wait for some time. Since we're going serially as of now, we'll complete the admission matters, the other admission matters. I think 2 or 3 of them left.
2 or 3 is left.
Once we are done that, we can come back to your case.
5 matters are left, my lord. After that,
Yes, after that.
admission matters.
Yes.
All right.
Hmm.
Let us make an attempt.
Yes.
Item 9.
Official respondent was supposed to file affidavit, lordship.
Lordship, we were supposed to file our affidavit, your lordship. Lordship, the report from the inspector of schools is awaited, your lordship, for which we are unable to place the instructions.
How much time?
Lordship will give us 2 weeks time.
2 weeks' time is granted to Ms. D.
Only date may be fixed, lordship. On earlier date, it was supposed to list after 2 weeks, but it was not listed.
2 weeks' time is granted to Ms.
D. Musahar,
D. Musari, Learned Council,
Standing Council, Secondary Education.
Learned Standing Council, Secondary Education Department to obtain instructions and to file the counter affidavit. List again on so and so. Give a date. Okay.
Obliged. Lord.
Obliged, lord.
May it please your lordship. In this matter, lordship, treasury officer has filed his affidavit in opposition, but the elementary has not yet filed any affidavit, lordship. Two opportunities were granted. On last occasion also, they took time, lordship. And their affidavit is very important, lordship, in this case.
Elementary.
Elementary, lordship.
Who's appearing for elementary?
Our instruction is awaited, my lord.
You want some more time?
So a short date may be
Ms.
given
S.
so that
Sutia,
they will
Learned
file.
Standing Council, Elementary Education Department, prays for and is granted further 2 weeks' time.
Lordship, may I
To-
pray for a fixed date, lordship?
File counter affidavit, list again on so and so.
Obliged, lordship.
Item 12.
Wait, please, your lordship. Bola, sir.
You have filed the additional affidavit.
Start with it, I have to conclude. It's able.
Your Honor, we are for the BTC, senior counsel, B. Bhuya is on legs. Kindly pass over the matter for some time.
B. Bhuya.
Yes.
She's also a counsel for BTC.
Yes, Your Honor.
For time being, he is asking.
For time being,
Hello.
pass over for some time.
Time being.
13.
When did the lordship? Lordship, on the last occasion, government took time to file affidavit, lordship. It has not yet been filed, lordship.
Which respondent is that? SSA. Who represents SSA? Elementary education.
Yes, madam. Yeah, madam, we have received instructions, so sometime we'll be allowed to file our affidavit manually.
Lordship is a second update petition, Lordship, regarding provincialization. 2 weeks from now.
How much time?
2 weeks from.
Miss N. Fukan, Learned Standing Council. Elementary
Yes, ma'am.
Education Department submits that she has received the instructions
Yes.
and prays that she may be given 2 weeks' time to file the counter affidavit. In view of above, list again after 2 weeks.
Lordship, can your date may be fixed, Lordship?
On so and so.
20.
Obliged, Lordship.
14.
Lordship. The department
They have filed.
not filed yet.
They have not filed.
Yes, ma'am. An affidavit is required.
time to.
How much time?
2 weeks.
2 weeks. Okay, as paid for by Mr. G. Pegu, Learned Standing Council, Elementary.
Yes.
Further 2 weeks' time is granted
Ma'am.
to file counter affidavit.
Already interim order may continue, ma'am.
List again after 2 weeks on a date to be fixed by the registry. Interim order shall continue to the next date of listing.
Ma'am.
Obliged.
I do.
Where's the council? Where's Mr. Mahanta? Huh? Yes, call. Timing.
Timing for
Alright, the matter relates to the selection and appointment of college discriminant. And a vacant post was advertised with the permission of the Director Higher Education in 2017. Advertisement, my lord, annexure 1, page 23. Well, the Sonari College, the respondent number 3 and 4. Issued an advertisement with the permission of the DSE for fill up of 2 posts. One is Assistant Professor Political Science and another is the Zoology. I am for the Political Science, my lord. Page 22. And my lord,
22, is this advertisement
yes, my lord, advertisement type copy, my
for
lord.
the post of?
I am for the post of Assistant Professor in Political Science, my lord.
I see.
What is the date of the advertisement?
My lord, 15/7/2017. It
15.
was published in Assam Tribune, dated 15/7/2017.
Okay.
My lord, my senior is coming, my lord. Now he will continue.
One post. This is
Yeah.
reserved for
For Silka.
scheduled caste.
My senior is coming, my lord. He will.
Of course, yes.
One post was advertised
Mhm.
for the post of reserved for SC,
Then,
assistant professor.
this is for which institution?
This is for Sonari College,
Sonar-
Shivsagar district, Sonari.
Where do we get that Sonari College? Okay, yes. Sonari College,
Shivsagar.
Shivsagar.
Shivsagar. So,
Hmm.
well, how did things started? Let us see that. Because this advertisement was issued pursuant to a direction of the Director of Secondary Education,
Hmm.
higher education. Huh? This is, Malad, page 27, Lordship will kindly come to.
Page 27.
27. This is dated 27/6/2017, right hand column top.
Alam, you may go. It'll take some time.
It was addressed to the principal, Sonari College, Sonari. Subject, can you see? Lordship got it, Malad?
Page 27.
27, right.
Yes.
Subject, permission for advertisement of the post of assistant professor.
Hmm.
It says, permission is accorded to the following post to be advertised in 2 local leading newspapers with a wide circulation for direct recruitment. Then assistant professor, number 1, political science, 1 post. It is reserved for SC.
Hmm.
Reserved for SC. Approval was granted earlier. So this is second post is for zoology. I am for political science. I am for political science.
Yes, please proceed. Thereafter, what happened?
To this, I applied. And here, one thing is very pertinent. Lordship will kindly come down to the last but one paragraph of this page 27.
Hmm.
In the event of first candidate joining elsewhere or not offering to join, the appointing authority may go in for preparing select list up to candidate number 3. In the competitive statement and not beyond, subject to approval of governing body. This is for avoiding successive re-advertisement for the same post.
So this is a relevant factor to be considered.
Yes.
Okay.
Yes. So, at this moment, what happened, my lord? I may give the facts. I participated in the process. I was selected and a panel of 3 members, 3 candidates was, successful candidate was prepared. Panel of 3 candidates, 1, 2, 3.
Where is that? Can we have a look?
Page 28.
Okay. What is your position?
My position was 3rd. My position was 3rd. Lordship has seen that at page 29.
Nilakshi Das.
No, Swarna Jyoti Das.
Okay, sorry, the last one.
Yes, last one. First one was Nilakshi Das. Number 1, right hand column, they have shown the position. Number 2, Devo Narayan Hazarika. That 2 was given, Roman. Swarna Jyoti Das, 3.
Okay.
So they prepared this panel of 3 candidates. And this was pursuant to the direction contained in this particular letter dated 27/6/2017, page 27. Thereafter, what happened? After this selection result came out, the number 1 selectee, he declined to come and join the post. He said that I do not want. He has got somewhere else, another college. Therefore, he declined. And when he declined, the authority recommended the case of the second candidate. Recommended the case of the second candidate for appointment to the Director of Higher Education.
Yes.
There, Director of Higher Education wanted that he should submit NOC, no objection certificate from his employer.
From the first person.
No, second person. First person declined. He didn't come because he joined in some other college.
Okay. NOC from whom then?
The second one, the second selectee, he was working in some other organization.
I see.
Therefore, at the time of submission of application, he ought to have submitted that no objection, but it was not there. But this fact came to the knowledge of the director. Director asked him that you produce NOC. He failed to produce the NOC. Thereafter, the director, instead of his candidature was rejected, therefore. that you could not produce NOC. And then the director asks that he cannot be, you forward another proposal. Second, number two, his approval was not granted because he could not produce NOC.
Okay.
Then therefore, it is for the governing body again to give a fresh proposal for the third one. And they forwarded my candidature.
Okay.
At that time, the second candidate, he approached this honorable court. That my case is not considered. Why? When this honorable court granted an interim order also, that meanwhile don't fill up the post. It remained as such, so my proposal remained in the file. And ultimately, he secured appointment in some other office through APSC and all, number two. And he ultimately came and said that, no, I am not pursuing it. I have got my relief elsewhere. I am not pursuing. So this honorable court said that in view of that position, now the authority can proceed in accordance with law to fill up the post. That was the final clearance given by this honorable court. And thereafter, governing body reiterated my proposal that now the third candidate remains and her appointment will be approved.
Yes.
And at that time, although it was there, the proposal remained pending, and it is pending till today. The director has not taken any step either to reject or to grant approval. At that stage, the petitioner had to approach this honorable court that how can he hold on indefinitely and or refuse to grant approval here when the candidate was duly selected. And here, the authority, the director and the government has taken a plea that the panel of 3 candidates itself is wrong.
Director said.
Yes. Now they take up the point. Director has, affidavit has been filed. Yes, take up. Say that the panel of 3 candidates could not have been prepared. There could not have been any panel at all. The number one, only one candidate ought to have been selected against one post. And once that candidate has refused to come, that gets exhausted, you will have to pursue a fresh course again for advertisement and selection. And they take this plea referring to the Act the FRBM. FRBM Act. FRBM Act is one. This was made in 2005. The Assam Fiscal Responsibility and Budget Management Act 2005. They take this plea by referring to, they say that this particular law, Assam Fiscal Responsibility and Budget Management Act 2005, it provides for only one. Here, Lordship will kindly see.
Which provision?
Provision at the section 7. Section 7, first Lordship will take up. I will first place the first few paragraphs. Then I will take your Lordship to the concerned provision.
I think it's under clause 7.
Yes.
Clause 7G.
Clause 7G. It says, notwithstanding any other provision contained in any act or rules, the select list prepared for the fresh appointments to vacate sanction post, appointment to vacant sanction post shall contain names equal to the number of vacant posts notified at the time of calling for applications for filling up the posts. Here it says, now, therefore the question would be whether this particular provision could have been applied in the given case, and it can be said that the preparation of the panel of 3 candidates could not have at all been permitted, and therefore the process itself was illegal.
Can you tell me the date of on which this act has come into force? Because it says from the date the government may notify.
Yes. It was, assent was received on the 13th of May 2005.
Subsection 3 of section 1. Or not section. Yes. Subsection 3 of section 1.
Yes,
That means there has to be a separate notification
yes.
that this is the date for effective date.
Official gazette
Hmm.
there date will be appointed. Received the assent, but when was it notified? That government may be able to tell us.
At any rate, they have applied this.
They now take this.
Okay.
Here only they have taken this point. Here only in this case, they have
Okay.
taken this clause. Otherwise,
Hmm.
referring to this or urging this point,
Hmm.
no order has been passed.
In the earlier writ petition filed by
Nothing.
the number 2 selectee,
No,
it was not raised.
no, that's why just I was,
Do you have a reference of that case?
yes.
What is that? WPC?
It was withdrawn. First case.
Withdrawn without any response.
Huh?
You have not filed counter on that.
Page 41, my lord, page 41 of the writ petition. Case number is there,
Hmm.
135518. It was second to the first. Kindly see, my lord. Lordship has raised the very vital question. Huh? 33. At page 33, Lordship may see.
Hmm. 33.
33, my lord. Here, this was the order passed in respect of this electee number 2. To the principal, this was addressed by the Director of Higher Education regarding approval of Assistant Professor, Department of Political Science subject, letter number so and so, reference. With reference to the subject cited above, I would like to state that the elected candidate for the post of Assistant Professor in the Department of Political Science, Sri Debo Narayan Hazarika, has been working as postgraduate teacher at Naharkatia Higher Secondary School. He has not submitted NOC. Hence, the proposal submitted by you has been rejected. So that time, the point that there could not have been a panel, the second candidate could not have been forwarded. This was not there. That point was never raised, not even raised here before this court also. Point
Okay.
was that he failed to submit NOC.
Hmm.
That was the point. And therefore, court says that you now proceed. Thereafter, third proposal means the only one candidate remain.
Where is that?
I am the only candidate remain in the list. 2 have gone already. 1 has declined to come. The 2 claimed, but he also declined ultimately. That no, I have got my appointment elsewhere. Therefore, I am not pursuing. He joined some other post. He abandoned his claim. Second also abandoned his claim. And third remained. Third proposal was forwarded. Third candidate's name was forwarded.
Hmm.
And this was done. The panel was prepared as per the direction of the authority. It was their stand. How can he blow hot and cold at the same time, the director? It was at the instance of the director.
Mr. Manta, you complete the facts first, then you come to the submission.
Yes, the factual part also. He himself said that you prepare, go for
You're
Three.
giving me both at the same time.
But yes, this also leads to submission, but then factual part is he himself asked that you go for a panel of 3 candidates. Now, thereafter, question is only question of law, whether such a plea is tenable in law. Now, what is the law? Kindly see. the law pertaining to the appointment of college teachers is regulated by the Assam College Employees Provincialization Act 2005. Page 490, Lordship will find in that book.
This seems to be a very popular book.
Yes.
We're full of flags.
See, because it contains normally all latest provisions, acts and rules.
490.
Yes, 490, madam.
Mm.
490. So this act received the assent of the governor on 19 December 2005. And it was notified on 22nd December 2005. So kindly see, my lord. Lordship has asked for that date of notification of the FRBM Act.
Mm.
That will be coming, I hope. It is not there. But this was at the same time, this was also in December 2005. FRBM.
Okay, now why are you showing me this act 2005?
Because here the provision, section 6, Lordship may come. Section 6 regarding selection and appointment of the employees. Appointments of both teaching and non-teaching posts in the colleges shall be made by the Director of Higher Education, Assam, on the basis of selection and recommendation of the governing body of the respective college in accordance with the rules and procedure of the government in force. So
So the college is a provincialized college.
yes.
And it is covered by this act of 2005.
Exactly. Provided that some of the powers of the appointing authority may however be delegated to the governing body of the college as may be provided in the rules. Now, it says, well, this is the enabling provision. Governing body is to take a decision and then select it and forward the proposal and the director will make the appointment. Now kindly go to the rules. At page 496, the rules are there. Lordship got it, my lord?
Yes. Rule
496.
number.
Rule number 6, 5 C. Method of recruitment. Method of recruitment. The recruitment shall be made in the manner prescribed hereinafter. Appointment to the post of principal shall be by direct selection for the governing body or to constitute a selection committee, which shall be, we can skip over. Kindly come to 2, sub-rule 2. For the post of
Lecturer.
lecturer, librarian appointment shall be, lecturer, librarian appointment shall be made by direct recruitment with prescribed qualification through open advertisement in 2 leading dailies, at least in 2 consecutive issues in respect of grade 3 and grade 4 posts. The list of candidates shall be collected from the local employment exchange advertisement in newspaper. Then we can skip and come to 7, sub-rule 7, my lord, Lordship may have. In all these cases, the governing body shall conduct the selection process and recommend to the director who shall issue orders of appointment. This I am laying emphasis. Lordship will note that it provides for lecturers, principals, librarians, and lower division assistants and all appointments. In all these cases, the governing body shall conduct the selection process and recommend to the director who shall issue orders of appointment. He shall issue. Director shall issue orders of appointment. It is very clear.
Assistant professor, same thing, isn't it?
Yes. Now it is
Lecturer.
there. Earlier it was called lecturer.
Lecturer, now
Now
it's
they are
assistant
assistant
professor.
professor, then associate professor, then professor.
Professor.
And this is how they have classified it. Now.
No, so
rules
far
are-
as the method is concerned, there is no issue.
No issue.
So far as the recommendation to be given
No issue.
and who is to appoint, there's no issue.
No issue.
Only issue now is whether one can prepare the panel list
Yes,
in excess of the number of vacancy
vacancy.
in view of this rules, whatever, what you call it, FRB rules.
FMBA Act, yes, sir.
And your submission would be that FRB rules
No, no,
was
no.
never an issue.
No, never any.
Nobody had taken that
No.
plea. Why have you taken this plea at this stage?
At this stage.
This is what your question.
Exactly.
Hmm.
This, at any rate, this was never an issue.
Hmm.
You never raised it in case of number 1, 2 also. Now in third case, you are raising this.
Hmm.
If it was illegal, it was illegally, it ought to have been taken as illegal at the inception itself. When the panel of 3 candidates was prepared, that time itself the authority could have said, no, we do not approve it.
Yes.
Otherwise, no. And here, can you come to Rule 7, direct recruitment?
You have just read Rule 7. Oh, not, you have not read. Okay.
Yes,
Direct.
to summary only. Now, Rule 7, it says, all appointment either by direct recruitment or by promotion shall be made by the director on the basis of recommendations of the governing body, based on the recommendations of the selection committee, departmental promotion committee duly constituted. Now B, the director shall communicate his order within 30 days.
Hmm.
So those 30 days mandate was there, that statutory mandate has not been followed at all. And the case was kept pending for no good reason. As a result, the college is suffering, students are suffering, I am also suffering, because with the hope, I am waiting for so many years.
Since when?
Since 2017.
17.
Yes. That post has not been filled up. The college students are suffering. And equally, I am also suffering. Now then, in view of this proposition of facts and the law, they are, as I have already submitted, they are only plea that the panel of 3 could not have been prepared in view of FRBM. Now, FRBM, what is this purpose?
Hmm.
Can you see? FRBM can be asked. Well, Lordship may also kindly note, as I said, this FRBM Act was made, it received the assent of the governor on 13th May 2005. And this act and rules, this College Employees Provincialization Act 2005 was also made in 2005, and it received the assent of the governor on 13th December 2005. What I mean to submit before your lordship is,
Yes.
had there been something of this sort, some embargo, the rule, the authority, the legislature would have provided here itself that look, while making such selections and preparing the panel of candidates, you are to follow FRBM and the mandate given there should be followed. It is not there. In the act also it was not there. The rules were made in 2010. Rules under this act, 2005 Act, was made in 2010. And this was notified at that time on 22nd November 2010. Here also, no indication, neither in Rule 5, nor in Rule 7, or in any other provision, there is any reference to FRBM. Laying down that there can be no panel, only one post. It should be against one post, only one selectee. There's nothing of that sort.
What is the main purpose of that?
Main purpose is kindly take up the fiscal responsibility and budget. Lordship will find it. There may not be there, my lord, in that book. এখন দিছা নেকি?
This FR, yes.
Yes,
have
yes,
a-
yes, yes, yes.
From where this is printed? Is it not contained in some book or something? FRBM?
Huh? That is a gazette notification, I suppose.
Not, this is not a gazette. I think this is printed like that, maybe from the website.
Website downloaded.
What is the copy you're holding? Is it a gazette copy?
No, it is a typed copy, my lord. It is of course.
You have the gazette copy? Print it, print it.
Gazette notification to আসেনি? This has the purpose only to organize the fiscal management. To regulate the fiscal management, nothing else. It is for the officers, management, the fiscal management officers, responsible officers to follow certain procedure to regulate the expenditures and see how smoothly those can be conducted so that there cannot be any subsequently found to be some irregularities in financial management. Financial management was, of course, a question. Therefore, this act was brought in, and it says to provide for the responsibility of the state government to ensure fiscal stability, sustainability, improve efficiency and transparency in management of public finances of the state. This is the prelude to the preamble of the act. Achieving enhance the management of the public finance of the state, enhance the availability of resources by achieving sufficient revenue surplus, reduce fiscal deficit, and remove the impediments to effective conduct of fiscal policy, and prudent debt management for improving the social and physical infrastructure and human development in the state. This is the preamble. And then Lordship will find the purpose is this. All definitions Lordship will find administrative approval, then annual budget, appointing authorities means officers of the state government exercising the delegated authority of appointing persons to the post and the state government. This is appointing authorities, current year, financial year, fiscal deficit. Explanation, Lordship will kindly see, for the purpose of calculation of fiscal deficit borrowings by the public sector undertakings and special purpose vehicles and other equivalent instruments where liability for repayment is on the state government are to be treated as the borrowing of the state government. Then plan outlay, fiscal indicators prescribed means that previous year revenue deficit, all these are pertaining to revenue. Revenue surplus, next please, my lord. Sanction, post. State government, financial department, total liabilities. Now, section 3 says, the state government shall in each financial year lay before the state legislature a 5-year fiscal plan along with the annual budget. This is how to be regulated, that section 3.
The act also provides for power to make rules.
Here also,
Any rules have been made, which is relevant for the subject?
rules are, is there rule? No. Right. Rules are not found, my lord.
Section 9.
Section 9 speaks of making rules, but whether rules are made or not.
Anyway, so that is your case.
That is my case, simple case. Simple case. Now, do you want to make it complicated by raising this point? No, FRBM will come into play. This honorable court has said FRBM has no relevance so far the appointments are concerned. I'll rely on that decision. Uh, This is lordship, volume has been given, vote of, yeah. Division bench. It is equal to what, sir? It is division, I don't know how to, more a question.
Dr. Ajit Kumar.
I'll come to it little later, my lord. First one, the Ajit Kumar Burwa and others,
Paragraph numbers.
43. This is 2013-1 GLR 345, Ajit Kumar Burwa.
And one is Arijit Paul.
Ajit Kumar Burwa.
Arijit Paul also.
And the second one, I will be relying on Ajit Paul. This is a division bench decision.
Yes.
Here it said, my lord, paragraph 10.
Paragraph 10.
Yes.
All right, we'll come back at 2, Mr. Mantha.
Yes.
We are submitting the judgment. First of all, take up the judgment of reported in year 2013. Yes, ma'am.
Correct. Yes. Lordship is taking up that Dr. Ajit Kumar Burwa's case, my lord.
Yes.
Here, this question was raised, whether FRBM can be applied. This was also a case of Assam College Employees Provincial Act 2005, under that act it was fulfilled.
What was the context of using this particular FRBM in
Yes, my lord, here.
this case?
Relating to charge the principal of the college, Lakhimpur, at page 3, Lordship, paragraph 3, man. Facts, let us see the facts here.
Why was it placed before the division bench? This is writ appeal. Oh, it's a writ appeal.
Division said they went on appeal.
Appeal.
Yes,
Please read paragraph 3.
yeah. The writ petition bearing number so and so, from which the present proceeding has arisen, was filed by one Sri Durgeswar Hazarika, response number 6 in the appeal. In respect of dispute relating to the charge of principal of the college called Lakhimpur Kendriya Mahavidyalaya. The challenge in the writ petition was the Annexure 15 order dated 31/3/2009 and Annexure 17 order dated 18/3/2009, an action passed by the principal of the Mahavidyalaya and the Director of Higher Education Assam respectively. By Annexure 15, order dated 31/3/2009, the resolution of the governing body of the college and consequential handing over of charge to the response number 5 therein was conveyed. The same resolution and action of the principal of the college was approved by the Director of Higher Education Assam by the approaches Annexure 17, order dated 18/3/2009. So these two orders, one by the principal, other by the approval granted by director. According to the petitioner, that is response number 6, because of non-sanctioning of the post of vice principal, in which capacity he had been discharging duties and functions, he had been deprived of being the in-charge principal. While adjudicating the said issue involved in the writ petition, learned Chief Judge took up the larger issue of appointment of principals in colleges on a regular basis and on the basis of the submission made by the Learned Standing Council, Education Department, that interview, selection and other process for selecting the candidates were already over. Held that the select list should be published. Accordingly, direction was issued to publish the select list and thereafter to make appointment on that basis as per the provision of law. As regards the issue raised in the writ petition, it was held that the absence of any provision in the rules that the vice principal should be allowed to hold the charge of the principal, the petitioner involved in the writ petition was not entitled to any superior claim over the respondent number 5 therein. Accordingly, direction was issued for continuation of the respondent number 5 as in charge principal for a period of 3 months and thereafter to take action for appointment of regular principal on the basis of this select list that was directed to be published. In the present proceeding, we are not concerned with the dispute between the respondent number 5 and the writ petitioner involved in the writ petition from which the present writ appeal and the writ petition have arisen. The issue involved is as to whether the selection of appointments of principal had been conducted in accordance with rules, and if not, whether the learned single judge could have issued the direction for publication of the select list and thereafter to make appointments of principal on that basis. The appellants, writ petitioners are working in provincialized colleges in Assam. They claim to be qualified for empanelment pursuant to the selection to be conducted by the State Selection Board, Assam, for the post of principal. Referring to the Assam Education Department Selection Rules 1981, the appellants, writ petitioners have contended that under Rule 10(1), the number of the selected candidate to be empaneled should be at least 3 times of the existing vacancies. They have also stated about the Assam College Employees Provincialization Act 2005, providing for provincialization of the services of the employees of the non-government colleges. Emphasizing on Section 6 of the said Act, it has been stated that the appointments against both teaching and non-teaching posts in the colleges should be made by the Director of Higher Education Assam on the basis of the selection and recommendation of the governing body of the respective colleges in accordance with the rules and procedure being followed. The above stand of the appellants petitioners has a vital bearing in the instant proceeding, inasmuch as the impugned select list has been prepared by Government of Assam in the higher education on the basis of the selection conducted by the State Selection Board, and in the process there is no association of governing body of the respective colleges. Since in the present proceeding we are concerned with the issue as to whether the select list was prepared in accordance with law or not, the basic facts related to the said issue are being briefly indicated. The selection in question was conducted pursuant to the judgment and order dated 15/2007, passed in the writ appeal, bearing writ appeal number such and such. The appeal was preferred against the judgment and order dated 19/6/2006 in WPC number such and such, whereby it was provided that the particular select list published on 21/6/2004 was valid till 21/6/2006. It was also provided that the select list would continue to operate for further period of 4 months up to 18/10/2006. In the said judgment and order, this significant observation made is in paragraph 6, dealing with the contention about the number of posts for which the particular advertisement was issued. The said observations is moreover, quote, moreover, this is not a case of selection for appointment. It is a case for selection of empanelment of teachers for the post of principal. Rule provides that persons who are empaneled in the select list are eligible for appointment to the post of principal, and the concerned college is required to make selection from the said list only. In the said appeal, the following direction was issued. We therefore direct the respondent authority, the selection board, to issue fresh advertisements in accordance with rule and regulations governing the matter, clearly indicating therein the number of vacancies for which advertisement is issued. The entire process of selection shall be completed and selection panel list be published within a period of 4 months. After the aforesaid judgment and order, the State Selection Board, Assam, issued an advertisement inviting candidates for selection of candidates for appointment of principals in provincialized colleges of Assam. In response to the said advertisement, candidacies were offered, including the candidacies of the appellants, lead petitioners. In acceptance of the candidacies, call letters had been issued for interview. After the interview, etc., the member secretary of the selection board, by its letter dated 13/2/2009, submitted the select list of the candidates for appointment of principals in provincialized colleges to the principal secretary to the government of Assam in the higher education. The select list was prepared in order of preference with the ratio of 1:3, keeping the said ratio against 51 vacant posts. 153 candidates were selected. It is the stand of the writ petitioners that the select list could not have been prepared in order of preference, as according to them, in fact, it was not a select list but an empaneled list of eligible candidates for selection as principal to be conducted by the respective colleges. By letter dated 13/2/2009, Annexure 9 of the writ petition, the government of Assam in the Education and Higher Department informed the Principal Secretary to the State Selection Board that the earlier direction for selection of principal against the vacancies at the ratio of 1:3 be restricted to the number of vacancies only, as per the provision of Fiscal Responsibility and Budget Management Act 2005, FRBM Act. Thereafter, the Principal Secretary, Government of Assam in the Education Higher Department issued office memorandum dated 24/2/2009 notifying that in view of coming into force of the FRBM Act 2005, the first sentence in Rule 10(1) of the Assam Education Department Selection Rules 1981 stood amended. The amendment of Rule 10 was indicated as follows. Publication of selection list of lecturers and principals.
This, Mr. Manta,
My lord.
this though you have already read in the rules, isn't it?
Yes.
The rules, no need to read. You may straight away come to the paragraph 43. Where FRBM Act has been mentioned.
Yes, yes. My lordship is referring to paragraph 43.
43.
No. Yes. As regards the applicability of FRBM Act 2005, on the basis of which the select list had been restricted to candidates equal to the number of vacancies, suffice it to say that provisions of the said Act cannot be applied beyond the object sought to be achieved by the Act. The Act was promulgated as a measure of financial discipline. Applying the provisions of the said Act, the authority could not have restricted the right of consideration for empanelment with eventual selection for the post of principal of colleges. Moreover, while doing so, the authority could not have overlooked the provisions of Section 6 of 2005 Act. As per the said provision, respective colleges are the selecting and recommending authority for appointment of the post of principal. So it is very clearly laid down that FRBM Act has no application so for the recruitment, making panels or selection of candidates are concerned. They are to be applied in the financial matters to strike the financial regulation, financial, to check the financial irregularities or to manage the financial affairs. The object is wholly different there. And that's why I submitted on, before going to break, my lord, that in the 2005 Act, that is the College Employees Act, or the rules in May 2000, then there is no reference of FRBM at all. There is also nothing to suggest that it should be selection to be restricted to the number of posts only, equal to the number of posts only. Rather than, therefore, the prevailing rule would be the instruction, executive instruction issued by the director himself to the college authority that to save the time or the expenditures, even that is also, my lord, FRBM, if the purpose to save unnecessary expenditure, then this is the right course. The director said that to restrict the repeated advertisements and process of selection, consuming time, energy, money, everything, you make a selection of 3 candidates, a panel of 3 candidates. Then you forward proposals. That was the first letter issued on the basis of which the entire process of recruitment was initiated.
Okay, now supposing that decision was sound, select one person but put somebody in the panel so that if number one, number 2 doesn't join, number 3 can join.
Yes.
So now question is, how long will that panel live? Does it have any life?
But, my lord,
Lifespan?
normally that list would continue for a year.
1 year.
Yes, normal rule is this. 1 year. Because there is nothing like, I didn't find in the rules also, that how long, what is the tenure of the list, select list. Nothing has been said there. And therefore, let us take to my respectful submission, 1 year term, and this was followed immediately. Within that time, it was followed, but meanwhile, the judicial proceedings was taken recourse to, and there was stay orders, and therefore, this could not be, it was halted. It was stopped. That period didn't start running to the end. Proposal was immediately forwarded. While authority took up the proposal of this petitioner, that number 2 candidate, whose candidature was rejected because of non-submission of NOC, he came and approached this court. Therefore, this honorable court passed an interim order and the matter stopped there. Finally, he had withdrawn. And court said that now you go ahead. So that
Alright.
being the position, my full submission. Yes.
That we have seen. Now coming to the second citation.
Yes.
Second authority. Arijit Paul.
Arijit Paul. It is read appeal again, my lord. Here, Lordship may see paragraph 2. Let us see the context, my lord. This inter-court appeal has been preferred against the judgment and order dated 2/1/2017 passed by the learned single judge in WPC so-and-so filed by the respondent number 5, whereby the writ petition was allowed by setting aside the order dated 8/7/16 issued by the respondent number 2. The facts of the case briefly stated are that there was a vacancy in the post of assistant professor of chemistry in the Sikkim Sarada College, Hailakandi, and the managing committee of the college headed by the principal in charge had issued an advertisement notice on 22/11/2015 inviting the applications from suitable candidates who fulfill the eligibility norms. In the advertisement notice published on 22/11/15, it was mentioned that preference would be given to the candidates having organic chemistry as a special paper. Altogether, 30 candidates, including the appellant, and the respondent number 5 had applied for the post, and the interview was held on 23/5/16, wherein 15 shortlisted candidates had participated. In the selection process, the respondent number 5 had secured 60.77 marks and had emerged as the top position in order of merit, whereas the appellants, having secured 59.94 marks, stood second. Notwithstanding the same, the selection committee had recommended the name of the appellant for appointment. Although no unanimous decision could be taken in the matter, yet the governing body of the college in its meeting held on 4/6/16 took a decision to place the matter before the Director of Higher Education Assam, respondent number 2, for taking a final decision on the matter. However, by the letter dated 18/6/16, the respondent number 2 had returned the matter back to the governing body with an observation that since the appellant had secured the second position and the respondent number 5 had come first in the selection process, and unanimous resolution in the matter be adopted after placing the same before the governing body of the college. Accordingly, the governing body of the college in its meeting held on 8/7/17 considered the matter and thereafter unanimously resolved to select and recommend the name of the respondent number 5, that is the first rank holder, for the post. Accordingly, the governing body had forwarded his name for appointment. On receipt of the said recommendation, the respondent number 2 did not approve the same, but had issued the letter dated 8/7/16 directing the principal of the college to reinitiate the process for selection of a candidate from amongst the candidates who have already appeared before the selection committee on 23/5/2016. Aggrieved by the order dated 8/7/16, the respondent number 5 had approached this court by WPC so-and-so by single judge judgment order. Mr. So-and-so submits that it was mentioned in the advertisement notice dated so-and-so that preference would be given to those candidates having organic chemistry as special paper. Since the appellant fulfilled the criteria and the respondent number 5 did not have organic chemistry as a special paper, taking note of the requirement laid down by the advertisement notice, the selection committee had rightly recommended the name of his client. He contends that the primary task of the selection committee is to assess the suitability of the candidate for the post in question, and having regard to the prescription of Rule 7 of the Assam College Employees Professionalization Rules 2010, for short Rules 2010, the governing body cannot sit in appeal over the decision of the selection committee and reverse the recommendations made therein. In support of his contents, Mr. Talukdar has placed reliance decision on the division bench of this court, that is Amit Sharma versus Jyotirmoy Bora, 2002 to GLT 45. The learned counsel for the appellant further submits that since the respondent number 5 had not been selected by the selection committee, hence the name could not have been recommended by the governing body. According to Mr. Talukdar, under the given circumstances, the only way out in the matter was to conduct a fresh selection as per the letter dated 8/7/16 issued by the respondent number 2. In that view of the matter, submits Mr. Talukdar, the learned single judge was not correct in allowing the writ petition. Now, my lord, let us come to 9 and 10. We have considered the rival submissions. Then 10, my lord. The procedure for making direct recruitment to the post of lecturers in the Provincial Health College in Assam has been laid down in Rule of 2010. As per Rule 7 of the Rules 2010, all appointments by direct recruitment is to be made by the director on the basis of recommendation of the governing body based on the recommendation of the selection committee. Rule 5(7) provides that it is the governing body which shall conduct the selection process and make recommendations to the director who shall issue order of appointment. From the aforesaid provisions of the rule, it is apparent that the responsibility to conduct the selection and make a recommendation of the candidates for appointment lies with the governing body, whereas the power of the director is confined to issue the order of appointment. In the present case, the governing body had constituted the selection committee comprising of experts so as to conduct the interview process. It is not in dispute that the respondent number 5 had secured the highest mark and therefore occupied the first position on merit, whereas the appellant came second. Notwithstanding the same, the selection committee had forwarded the name of the appellant as the selected candidate. Such a course was apparently taken by the selection committee in view of the preference criteria mentioned in the advertisement notice. Although the governing body had initially forwarded the name of the appellant, yet the matter having been returned back by the director for passing an unanimous resolution, the meeting of the governing body was concerned on 8/7/16, wherein the following resolution in the form of resolution was passed. 3. Resolution regarding the appointment of assistant professor in the Department of Chemistry as per DH's letter number so-and-so dated 18/6/16. It is unanimously resolved and selected the first rank holder in the interview, Dr. So-and-so, for the appointment of the post of assistant professor in the chemistry department, and the principal is requested to submit papers for Dr. Khan, DHA, early possible. From the above resolution, it is clear that the governing body had chosen the first rank holder, that is the appellant number 5, and recommended his name for appointment of the respondent 2. Since the resolution adopted in the meeting dated 8/7/16 was based on authentic data available before the governing body as regards the merit position of the candidates, having regard to Rule 5(7), we are of the view that the governing body was competent to select the first rank holder and recommend his name for appointment. Such decision of the governing body, in our opinion, cannot be held to be sitting in appeal over the decision of the selection committee, since there is no difference in opinion between the selection committee and the governing body on the point that the respondent number 5 has secured the highest marks. In view of the above, the decision of the case of Amit Sharma so-and-so relied upon by Mr. So-and-so cannot be any assistance to him in the present case. In the learned single judge had held that the appellant had secured lesser marks than the respondent number 5, and therefore the question of giving preference to the candidate securing lesser marks did not arise. It was also held that the governing body was right in adopting the resolution that is so-and-so, and therefore the Director of Higher Education was not justified in issuing the letter dated 8/7/16, directing initiation of fresh selection process. We find ourselves in complete agreement with the view expressed by the learned single judge. Since the governing body has recommended the name of the first rank holder, no fault can be found with the resolution of so-and-so. Moreover, the appellant has not challenged the resolution that is so-and-so of the governing body meeting held on 8/7/16, recommending name of the respondent number 5 for appointment. As such, we are of the view there has been no valid ground available for respondent number 2. In this case, not accepting the said recommendation of the governing body to appoint the respondent number 5 had instead directed fresh process of selection. Therefore, my lord, ultimately at this stage, the learned counsel for respondent prejudice due to delay in service notice appeal, my lord, petition was ultimately, appeal was allowed. Merit, and it same is accordingly dismissed. My lord, that means the single judge's order was upheld. So here also, my contention will be on the basis of paragraph 10, my lord. He says, from the said, he has quoted Rule 10 and Rule 7 of the rules, 5(7), and then said, paragraph 10, my lord. From the aforesaid provisions of the rule, it is apparent that the responsibility to conduct the selection and make recommendation of the candidates for appointment lies with the governing body, whereas the power of the director is confined to issuing the order of appointment. Now, this being the position. So far, that question of panel That panel was upheld in Dr. Ajit Kumar's case. And court has categorically said that FRBM has no application. So far, these cases of recruitment and appointment are concerned, its aim is different, object is different.
So that is your case, Mr.
My
Malik.
case is.
I've understood. Anything else?
Well, the only thing is, Lordship may also kindly note that all these processes are going on, the director or no other authority above him ever issued any letter saying that we are withdrawing the first one, you go for fresh selection. No, nothing. This, the first, whatever this direction was issued that you go for selection and recommend, that existed. This page 27. This remained. This was never withdrawn or they never issued any fresh direction. This remained. Therefore, here also they have found, they are also, as I have submitted already, 2010, 2005 Act, FRBM, all were before them. No indication, nothing. Never insisted that that should be done or it should be proceeded accordingly. Therefore, my respectful submission, the director has no option but to issue the appointment letter.
Okay.
That has not been done, he is holding back.
Okay,
Lordships will be pleased to direct them to issue immediately appointment order.
all right. Let me hear the other side.
Well,
You are the governing body and you are the director. And middle one, Mr. Das, you are the, oh, you'll be assisting, okay. Yes.
May it please your lordships. Also here also after going to the pleadings for all side lordship, my lord have to decide two moot questions here. Number one is lordship whether authority can prepare a panel list, access the post advertise when or whether authority can act upon as per the procedure of this act lordship. Number one, that is lordship. And then lordship whether the letter dated 27/6/2017 legally enforceable when there is a statutory act or rules. That two moot questions my lords have to decide in my point of view, lordship. In respect of lordship, regarding preparation of pen, just I shortcut everything, I will not take much time, lordship. Just making it ready. Everything ready. Here lordship, they are basically pressing that page 26 lordship. Page 26. It starts from page 24 lordship. Page 24. This is the letter 27/6/2017 lordship issued by the Director of Higher Education Assam lordship. Then page 26, my lord may kindly come lordship. In the event of first candidate joining elsewhere or not offering to join, the appointing authority may go for preparing select list up to the candidate of 3 in the comparative statement for the same post.
Yes.
On that particular lordship letters, that on that basis lordship, they have argued that there should be a 3 panel list lordship. And my one of the moot question is lordship, whether that letter dated 27/6/2017 lordship legally enforceable when there is a statutory act or rules lordship. So my lord, kindly come to the rules lordship. Before that act lordship.
Which one? The act.
Act lordship. Act is lordship, page 490 lordship.
Section.
490. Section lordship 6, Lordship.
Yes.
Selection and appointment of employee, Lordship. Appointments of both teaching and non-teaching posts in the college shall be made by the Director of Higher Education Assam on the basis of selection and recommendation of the governing body of the respective colleges in accordance with the rules and procedure in the government in force, Lordship. My lord, may I kindly mark the rules and procedure, Lordship. Then, my lord, may I kindly come to next page, Lordship. Section 12, Lordship.
Yes.
It's a rule-making power, Lordship. Power of the government to make rules, Lordship. Except for the purpose of payment of pension, which will be governed by the Assam Service Pension Rules 1969, the state government may by notification in the official gazette make rules for carrying out the purpose of this act, Lordship. Then, my lord, may I kindly come to next page, Lordship.
Rules.
This is the Assam College Employees Provincialization Rules 2010. In exercise of power conferred under Lordship, Section 12(1), that previous Lordship. Section 12(1), where the rulemaking powers is given by the Act, Lordship. On that basis, that particular Act was, Lordship, enacted by the Government, Lordship. 309 rules, Lordship. So, Lordship, here method of recruitment is Rule 5, Lordship.
Yes.
Rule 5, in this case, 5(2) is applicable. For the post of lecturer/librarian, appointment shall be made by the direct recruitment with prescribed qualification to open advertisement into leading the list at least into consecutive issues, Lordship. Then, my lord, may kindly come to next page, Lordship, Rule 7, Lordship. 5(7), Lordship. In all these cases, the governing body shall conduct the selection process and recommend to the director who shall issue orders of appointment. This is the procedure, Lordship. And then, Lordship, direct recruitment part. 7, Lordship, 7A. All appointments either by direct recruitment or by promotion shall be made by the director on the basis of the recommendation of the governing body, based on the recommendation of the selection committee, departmental promotion committee, that is not required, based on the basis of the recommendation of the selection committee, Lordship. Here, Lordship, the rules and Act, Lordship, nowhere provide for, Lordship, preparation of a panel list or wait list, Lordship. Only it says that, Lordship, on the recommendation of the governing body, the authority have to appoint the particular persons, Lordship. There is no provisions for, Lordship, waiting list and panel list in the statutory prescription, Lordship. In respect of that, we have filed our affidavit, Lordship. Affidavit we have filed, Lordship. It is running page. It starts from 48, Lordship.
Yes.
Paragraph 5, we have reiterated, Lordship, in respect of the, Lordship, that particular persons, Devakumar Narayan, who was, Lordship, recommended. Then, Lordship, paragraph 7. Then paragraph 8, Lordship, just the act and rules which I have placed, it was reiterated, Lordship. Then, my lord, may kindly come to paragraph 9, Lordship. The deponent begs to state that there is no provisions for making a panel or waiting list for selection and appointment of any post, including the post of assistant professor, under the Assam College Employees Provincialization Act 2005 and the Assam College Employees Provincialization Rules 2010 and the Office Memorandum Guideline issued from time to time for selection of the assistant professors of provincialized college in the Assam, Lordship.
Mr. Gogoi, you are referring to affidavit filed by?
Affidavit filed by the Director of Higher Education, Assam, Lordship.
Director is respond number?
Respondent 2, Lordship.
2. What is the page number?
Running page is 48, Lordship.
48 is by 3 and 4 affidavit.
3 and 4.
Governing body.
82, my lord. 82. Running page 82, my lord.
Running page 48 is by respondent number 3 and 4.
Then just well, kindly hand over it. I'll. It running page 50.
Here affidavit starts from 77 running page.
Running page no type number. By the reason, by the reason. My lord, may I kindly come to paragraph 9, Lordship. Paragraph 9, Lordship, of the affidavit.
Yes.
That the deponent begs to state that there is no provisions for making a panel or waiting list for selection and appointment of any post, including the post of assistant professor under the Assam College Employees Provincialization Act 2005 and the Assam College Employees Provincialization Rules 2010 and the office memorandum / guidelines issued time to time for the selection of assistant professor of a provincialized college in Assam, Lordship. Even, Lordship, the office memorandum and guidelines, Lordship, which are issued by the government, which should be followed for the appointment of assistant professor as well as other posts, Lordship. Here also there is no provisions for preparing a panel list, Lordship. As there is no rule requiring for preparation of a panel list or wait list for selection and appointment of the assistant professor in the provincialized college, if the recommended candidate does not join or if the recommendation and the proposal is rejected by the directorate, it is the duty of the authority of the concerned college to re-advertise the post, Lordship.
Yeah.
Then, Lordship, paragraph 10. That the deponent begs to state that for administrative approval, appointment, financial liabilities in respect of appointment for any post under the government of Assam, the provisions for Assam Fiscal Responsibility and Budget Management Act 2005 are strictly followed, Lordship. And in the FRBM Act 2005, also there is no provisions for making a panel or wait list for selection of the appointment of the candidates. Basically, these two paragraphs I am relying, Lordship.
Yeah.
Regarding FRBM, my lord, may again kindly peruse FRBM, Lordship. Definition clause, my lord, may kindly come to 2C, Lordship.
2C.
2C is the appointing authority, means officers of the state government exercising the delegated authority of appointment persons to the post under the state government. Here, Lordship, director is the appointing authority as per the, Lordship, procedure prescribed in the rules 2010, Lordship. Then, Lordship, sanction post is M, Lordship. Next page, Lordship, M.
M.
2M,
Yes.
2M, Lordship, 2M. Means the post which were created by a sanction of the state government and has not been subsequently abolished or kept in abeyance by any order of the state government, Lordship. Then my lord may kindly come to, Lordship, 7, Lordship. Section 7, Lordship.
Yes.
Section 7, 1A, Lordship. Section 7 is in respect of measure to ensure fiscal discipline, Lordship. The state government or the appointing authority under it shall give appointments only against a sanctioned post which is vacant and in accordance with the laid down rules and procedures and orders. My lord may kindly mark it. In accordance with the laid down rules, procedure and orders, Lordship. Then my lord, Z, Lordship. 7Z, Lordship. 7G, Lordship.
Yes.
Notwithstanding any other provisions contained in any act or rules, Lordship, the select list prepared for the first appointment to vacant sanction post shall contain names equal to the number of vacant posts notified at the time of calling of the appointments for filling up the post, Lordship. Here, Lordship, the number of posts is 1, Lordship. Here, one point was raised by my senior sir, Lordship, regarding first candidate. Before recommendation was made, Lordship, that particular candidate was withdrawn from the rest, Lordship. As because she was appointed in other colleges, before governing body take a resolution, that particular candidate was withdrawn, Lordship.
Number 1.
Number 1 is withdrawn from Ferry, Lordship. Before governing body take a resolution, I have the records, Lordship. I have the original records, Lordship. No recommendations, no proposal was taken in respect of that particular candidate, Lordship. Then, Lordship, the persons who were recommended, Lordship, his recommendation was Devakumar Narayan was, we have rejected it, Lordship. On the ground that, Lordship, although it is written that no NOC was given, Lordship. He was recommended by the, only that particular candidate was recommended to us, Lordship.
Number 2 was recommended,
Only that candidate was recommended.
but there was no NOC.
Though there was no NOC, that's why his candidature was rejected. He has put to silence it before the honorable court. Later on, he withdrawn the writ petition also.
Okay. Why did he put to challenge?
He silenced that particular
NOC.
NOC condition also.
I see.
NOC condition, he was silenced also.
I see. Then came the present petitioner.
Present petitioner, Lordship. The basic reason is that, Lordship, there is no provisions for preparing a panel list, Lordship. If one have not joined that particular post, or if the recommendation is rejected by the directorate, Lordship, then it should be go for the test selection, Lordship. And there is no statutory prescription prescribed by the panel list, Lordship. Nowhere. Rule 5, Act 5 and Rule 10 also, Lordship. Nowhere there is a procedure, Lordship, for preparing the panel list, Lordship. He said to the job.
What about the petitioner? Was his name forwarded?
Lordship?
The petitioner, was his name forwarded? Come to page 37.
Page 37. Yes, yes. Page 37. Lordship.
This is the petitioner.
Lordship.
Resolution in favor of the third.
The resolution is there, Lordship. One resolution is.
Was it forwarded?
It was.
Where is the forward letter?
35.
35.
In my already.
Oh, it was forwarded. Okay.
In page 37, it is there, Lordship. Our contention is that, Lordship, that particular recommendation by governing body, we cannot accept. On the basis of that, there is no provisions for panel list or, Lordship, preparation of wait list.
Did you reply to this?
Lordship?
Did you reply?
Lordship, we have paragraph 9 and 10, Lordship, we have stated, Lordship.
No. This page 35.
35, Lordship.
Enclosing the resolution. You do not act upon it.
We are not act upon it. That's because, Lordship, there is no provisions for panel list or.
Neither said yes, neither said yes or no.
Lordship.
Then the petition came.
In the meantime, they have filed before taking any decision, they approach this court.
I see.
So
there was no decision as such.
There is no decision. There is no decision. Otherwise, it can be treated as a premature one also, Lordship. As per the judgment of our High Court, Lordship. Yes, because there is no decision is there, it is a premature one. And a record recommendation is there, Lordship. Record recommendation is there. Judgment of
So matter boils down to that issue only,
Lordship, yeah, only that issue, Lordship.
whether panel list can be prepared,
Lordship.
and if it is prepared, whether the director is bound to act upon it. On a point.
So Lordship, I am relying in respect to the panel list, Lordship. I am relying, Lordship, three judgment, just I indicate two judgment. It is take up to correction. It is air allegation, air mug air copy. Air copy to good game. Air copy to good game. Let's see. Let me start with the good person. এটা না লাগে সেকেন্ড মোটরটা কাট দিলে নি কোটা
How many decisions you're giving me?
Lordship, I will rely, Lordship. Every point I will rely. In respect of Lordship, waiting list, I will rely his judgment, waiting list part. And statutory rules, I am relying two judgment. And act should be done, that I am relying one judgment. Director powers one judgment and FRBM one judgment, Lordship. Total, I am relying, Lordship.
What is the first one?
What film will you go? Photo, head one from that video. So, my lord, first, my lord, may kindly take the judgment of 2022 AR-SC 2949. What's the result? So, you put it on the other. That AR copy to dia question na, so yet SCC online copy to mono copy dile can I solve it? So, my lord, may kindly come paragraph 40. My lord, got it, Lordship?
No, I have not got it. The name of the party?
I'm sorry, but division.
Name of the party?
Parties, Lordship, Bhalampati, Satish Babu.
Oh, yes, I got it.
Yeah,
I got it.
Paragraph 44, 4.4, Lordship. Just my lord may indicate 4.4, 7.4, 7.5, 8.1 and 9 Lordship.
8.1 and 9.
Lordship. Now I am 4.4 Lordship.
This is regarding
This is regarding Lordship wait list.
waiting list.
Waiting list or panel list, Lordship. Yes, because there is no statutory prescription, so Lordship that cannot be.
Yes.
4.4 Lordship. Relying upon the decision of this court, relying upon the decision of this court in the case of Bihar State Electricity Board, Suresh Prasad and others, I have already that judgment, I have already forwarded Lordship 2004 to SCC 681. It is vehemently submitted by C. Sobenso Learned Counsel appearing on behalf of the respondent state that as held by the court in the aforesaid decision, where the rule do not envisage drawing up a waiting list, no wait list candidate could be appointed as a result of the non-joining of the selected candidate, Lordship. Here also, Lordship, in our rules, Lordship, there is no provisions for preparation of wait list and Lordship, panel list, Lordship. Then my lord may kindly come to 7.4, Lordship. In the present case, the final select list, my lord got it?
Yes.
Of 33 candidates was prepared. Thereafter, all the selected candidates were called for counseling, but one of the candidates did not report for counseling. The appropriate event took place after the final select list was prepared and published. As there was no requirement for preparation of waiting list, the appellant claiming to be the next in the merit cannot claim any appointments as her name neither figured in the list of the selected candidates nor in any waiting list, as there is no provisions at all for preparation of waiting list. Sub-rule 5 of Rule 16 is very clear. Therefore, the post remain unfilled due to one of the candidates in the final list did not appear with counseling and accepted the employment, and the post has to be carried forward in the next recruitment also. Here also, there is no provisions for lordship preparing a select list or wait list lordship. Then my lord may kindly come to 7.5 lordship. Next page lordship.
Just a minute.
Sale ko dito kita. Kobita ulesa kobita kodbo. Rotation to double bhagwake bhayar ase na jati jati. 7.5 lordship.
Just 1 minute.
মনোযোগ আছে।
7.5.
7.5 lordship.
Yes.
The appellant could have claimed the appointment to the post which remain unfilled provided there is a provisions for waiting list as per the statutory provisions lordship. In absence of any specific provisions for waiting list, on the contrary, there being a specific provisions that there shall not be any of the waiting list and that the post remaining unfilled on any grounds shall have to be carried forward for the next recruitment. The appellant herein does have no right to claim any appointment to the post which remain unfilled lordship. Then say 8.1 lordship.
Yes.
An identical question came to be considered by the court in the case of the so-and-so lordship. In the said decision, it specifically observed that and held that even in case candidates selected for appointment have not been joined, in absence of any statutory rules, to the contrary to the employer is not bound to offer an unfilled vacancy of the candidates next below the candidates in the merit list lordship. It is also held that in the absence of any provisions, the employer is not bound to prepare a waiting list in addition to the panel of selected candidates and to appoint the candidates from the waiting list in case of candidates from the panel not joined lordship. The aforesaid decision of the court has been subsequently followed by so-and-so lordship. Then my lord, another judgment is there. Student. This lawsuit is State of Uttar Pradesh versus Kurnesh Kumar lawsuit.
Yes.
Paragraph 30 lawsuit.
30.
30 lawsuit.
Yes.
The aforesaid decision in our considered view may not have been any application to the case on hand on it. The effect of the relevant rule is not considered therein, as the select list shuts the door to everyone up other than the selected candidates. The aforesaid decision was in the context of so-and-so. However, as we held that in the 1978 rules do not apply in the present recruitment, the aforesaid decision would not be in any service. Further, it is settled law that there is no vested right to the unsuccessful candidate to insist upon the consideration in the absence of any such rules requiring for preparation of a waiting list. My lord, may kindly mark it. The recent decision, the decision which I am relied, that was lawsuit quoted here lawsuit.
Unsuccessful candidate. What does it mean?
Lordship, the selected candidate, first selected candidate, so lordship, who has the top of the merit, he can be treated as a successful candidate, and those candidates who, on the basis of the merit, lordship, as recommended, he should be treated as a successful candidate, lordship. Here, lordship, there is no provisions for preparing a wait list or panel list, Lordship. That's why Honorable Court says that, Lordship, when there is a no specific provisions prescribed in the statute, Lordship, we cannot go beyond that, Lordship.
The earlier decision was relied upon.
Earlier decision was relied, Lordship.
Golampati Satish Babu.
Lordship, that was relied. That was relied.
In which paragraph?
In paragraph, Lordship, 30 itself. 30 itself in 7.4, 7.5, 8.1, Lordship.
Yes, next page.
Then my lord may kindly come to page 24 letter also. On that particular letter, 24 letter, it is in repetition also. Page 24 also. Page 24 also. 27/6/2017 also.
Yes.
In page 26 lawsuit, by way of this letter, the deed and director has stipulated that lawsuit, page 26. In the event of first candidate joining elsewhere or not offering to join, the opportunity or appointing authority may go for preparing a select list up to the candidate number 3 in the comparative statement for the same post lawsuit. Whether that can be treated as a lawsuit valid or whether that particular letter have an statutory force lawsuit. While there is a statutory enactment is there is a statutory prescription is there under 309 rules lawsuit, whether that particular by way of that particular letter, the authority can override the statutory prescription lawsuit. In that particular aspect lawsuit, I am relying with us to judgment lawsuit. So lawsuit here 2022-11 SCC 392.
Party's name?
Party's name is Employees State Insurance Corporation versus Union of India and others lawsuit. Here also I am relying paragraph 13, 16, 17 and 21 lawsuit. Paragraph 13 lawsuit. A two-judge bench of this court in so and so lawsuit interpreted a similar power to frame regulation under the Road Transport Corporation Act 1950. This court held that regulations made under the statute have the force of law lawsuit. It is well settled law that the regulations made under the statute laying down the terms and conditions of the service of the employees, including the grant of retirement benefits, have to be force of law. The regulations validly made under the statutory power are binding and effectively as the enactment of the competent legislature. The statutory bodies as well as general public are bound to comply with the terms and conditions laid down in the regulations as a legal compulsion. Any action or order, my lord may kindly mark it, any action or order in breach of the term of the conditions of the regulation shall amount to violation of the regulations which are in nature of the statutory provisions and shall render such actions and order illegal and invalid lawsuit. Here lordship, the statutory prescription prescribed by 2010 rules, there is no provisions for preparing a panel list or wait list. But the deed and director has issued one letter. It is not an office memorandum also, lordship. One letter whereby he has directed the college authority, if first candidate is not joined, they have prepared a select list up to panel of 3 lawsuit. In view of the law laid down by the Honorable Apex Court lawsuit, that cannot be sustained lawsuit. Then paragraph 16. And that particular letter was issued, Lordship. Page 24 letter was issued, Lordship, only to the principal of that particular college's, Lordship. Particular college, my lord, may kindly, for a moment, kindly peruse page 24, Lordship, before going to that particular jargon. Just I point out, Lordship. Page 24. My lord, got it?
Yes.
Page 24, Lordship. To the principal of Sunari College, Lordship. My lord, got it?
Yes.
Only that particular college, Lordship, the rule was violated by that particular gentleman, Lordship.
But vacancies to be filled up for that college only.
Lordship, rules should be equal for
So-
all the colleges, Lordship.
No, the rule is something else, but.
But
there-
that is
there-
there, Lordship. That is there. He cannot issue a directions by contravening the provisions of the rules.
There are two vacancies. One is that political science, one is
That
zoology.
is there. That is there. We are not
So-
disputed that.
So for that reason, the letter has been addressed to that college.
We are not disputed that. Letter was issued by that particular person.
If there is no post to be filled up in any other college, why should they write to other college?
Lordship, every moment, Lordship, it should be generalized. Even generalized also, Lordship, it cannot be, Lordship.
No, this is not an OM. That is not a dispute thing.
Just I indicate, Lordship.
It's a
Now,
letter.
Lordship, paragraph 16, Lordship. Paragraph 16.
Yes.
In so and so, at two judges bench of this court, speaking in the context of service regulations governing a departmental inquiry, reiterated that an office order or office memoranda cannot contravene the statutory rules. Lordship. My lord, may kindly mark it.
But this out here, there is not even an office memorandum.
Not even an office, only a letter, Lordship.
Hmm.
Only a letter, Lordship. That letter, Lordship, cannot override the Lordship. Even office memorandum also not override the statutory prescription, Lordship. Here is a letter issued by the one gentleman, Lordship. The law laid down above has consistently been followed, and it is a settled proposition of law that an authority cannot issue orders or office memorandum, executive instructions in contravention of the statutory rules. However, the instruction can be issued only to supplement the statutory rules, but not to supplement it, Lordship. Such instructions should be subservient or to be statutory provisions, Lordship. Then my lord may kindly come to paragraph 17, Lordship. 17 reiterated the same, then my lord may directly come to paragraph 21, Lordship. It will be reviewed. In so and so, Lordship, two judges bench of this court followed the decision of so and so in interpretation and advertisement issued by the director, Social Welfare Uttar Pradesh for the position of the psychologist. The court declined to give precedence to the erroneous qualification prescribed by the advertisement against the relevant recruitment rules, Lordship. Then, Lordship, 27, middle portion, Lordship. Any part of the advertisement which is contrary to the statutory rules has to give way to the statutory prescription. Thus, looking into the qualification prescribed in the statutory rules, the appellant fulfills the qualifications, and after being selected for the post, denying appointment to him arbitrarily illegal. It is well settled that when there is a variance in the advertisement in the statutory rules, it is the statutory rules which take precedence, Lordship. Here, Lordship, statutory rules prescribe there is on no prescriptions for no panel list, and Lordship, there is no indication of panel list, Lordship.
Okay.
That's why, Lordship, it will be, Lordship, as per the statutory prescription, Lordship.
That's
Then, my lord, 2025 SCC online SC 109. R. Rajnit, Rajnit, Lordship. R. Ranjit Singh, Lordship. 19, 20, and 21, Lordship. I am relying paragraph.
Hmm.
19, my lord, may I kindly come to last line, Lordship. Paragraph 19, Lordship. My lord, got in 19.
Yes.
We start from last line, Lordship. Other text is above there. It is well settled, my lord, got it. It
Yes.
is well settled proposition of law that executive instruction cannot supplant the statutory rules. They can supplement and clarify the statutory rules. In the present case, the executive instruction issued from time to time have in fact supplanted the statutory rules, and such a process is unheard in the field of the service jurisprudence. Exactly similar in our case also, Lordship. And 20 and 21, Lordship. Sir, it was 2025 SCC online SC 1009. 2021, Lordship. May I read, Lordship?
Yes.
Lordship. The court in the case of so-and-so was held that the executive instruction can supplement the statutory and cover areas which statute does not extend. They cannot run contrary to the statutory provisions to settle down their effect. And in the present case, so-and-so are executive instruction, and based upon the executive instruction, the statutory provisions as contained under the statutory rules could not have been made applicable as has been done in the present case. Then Lordship 21. 21 paragraph is also on the basis of the one of the latest judgment of the Honorable Apex Court, Lordship.
Yes.
It can, Lordship.
I've seen it.
Lordship. Then, Lordship, I am relying another judgment, Lordship, which, Lordship, is a well settled golden principles of law, Lordship, that act should be done in a particular way, which was prescribed in that way, Lordship. It is, I am relying the judgment of 2022 SCC online SC 909, Lordship. Union of India versus Mohendra Singh, Lordship.
Paragraph
14 and 15, Lordship. Paragraph 14 is, Lordship, on the basis of the, Lordship, the golden principles of law laid down in the Privy Council cases in the Nazir Ahmed, Lordship. I am not retired it, Lordship.
Not required.
And paragraph 15, Lordship. Paragraph 15 was also on the basis of that principles was laid down in the Privy Council, and which was later retired in Sondakishu's case, Lordship. And Serukuri Moni's case, Lordship, it was retired, Lordship. So, Lordship, here the statute prescribe and particular procedure for, Lordship, selection and appointment, Lordship. There is no procedure for preparing a panel list or wait list, Lordship, in the statutory prescription, Lordship. So we have to go by the prescription prescribed by the statute, where it was envisaged that there should not be any, Lordship, panel list, Lordship. There is no mention regarding panel list, Lordship. And another regarding director's power, Lordship. It is case. In Minal Kumar Borwar's case, 2017 1 GLT 77, Lordship.
Paragraph
11 and 12, I am relying, Lordship. Paragraph 11 আছে না? Paragraph 11, Lordship. It's a long paragraph, but ultimate finding is, Lordship, paragraph 12. I am relying paragraph 11 and 12, Lordship. Just I reading paragraph 12, Lordship.
Yes.
At first blush, it would appear that once a recommendation is made by the governing body, the director has no discretion but to issue order of appointment. Rule 7A provides that all appointments either by direct recruitment or by promotion shall be made by the director on the basis of the recommendation of the governing body, based on the recommendation of the selection committee. As per clause B of the director is required to communicate his order within 30 days. As per clause C7 of clause C of Rule 7, in respect of the post for which UGC has prescribed norms, no candidate shall be recruited without having the required norms, Lordship. Therefore, from a careful and conjoint analysis of the provisions of Rule 5.1 Rule 5.1 of Lordship, that 2010 rules, Lordship. And Rule 7 of 2010 rules. What logically emerges is that before according approval to the recommendation of the governing body and before issuing order of the appointment, the director should satisfy himself that the selection and recommendation was carried out in accordance with law, Lordship. He should also satisfy himself that in respect of the post like so and so, laid down details eligibility norms recommended so and so. Then, Lordship, the court in so and so held that the issuance of last 3 lines, Lordship.
Yes.
The issuance of appointment order by a director is not an empty formality. The director of higher education before passing such order is required to scrutinize the selection record and only after being satisfied he is to issue the consequent appointment order, Lordship. So, director powers is, Lordship, already elaborately discussed by our High Court, Lordship. It's not an empty formality, Lordship. Before issuance of the appointment order, Lordship, you have to go to the, Lordship, the recommendation given by the governing body as well as the records, Lordship, whether the rules is followed or not, Lordship. If rules is not followed, then, Lordship, he can reject it. And if rules is followed, it is bound by him to, Lordship, appoint, Lordship. Here the rules is not followed, Lordship. There is no provisions for prescriptions for wait list, Lordship. Huh? In respect of the FRBM, Lordship, I am relying one judgment of the Honorable Apex Court, Lordship.
Which is?
Dhanraj versus Vikram Singh, Lordship, 2023 SCC Online SC 724, Lordship. Para 13, Lordship. I am not troubling para 13 last 3 lines, Lordship.
This is FRBM.
It is not basically not directly FRBM, but, Lordship, perimeter provision is there in the PSA Act. So, Lordship, paragraph 13, last 2 lines, last 3 lines, Lordship. Without holding that the statutory provisions are not constitutionally valid, the High Court could not have issued a direction not to implement the statutory provisions, Lordship. Even that particular paragraph I am relying in respect of, Lordship, waiting list also, Lordship. Not only FRBM, I am relying it for the waiting list as well as other purpose also, Lordship.
But how do you apply this to your case?
Lordship.
How is it relevant?
Yes, because, Lordship, the FRBM Act is never declared as a constitutionally invalid, Lordship. It is still in force, Lordship, and on that basis, Lordship, all selection was done by the government of Assam. Okay, thank you.
That leaves us with one more judgment.
One another, and Lordship, I am relying also constitutional provisions of Article 166 in respect of that particular letter to invalidate that particular letter, Lordship. Article 166, Lordship. But the economy.
One 166.
No,
What does it say?
It says that conduct of the business of the government of state, all executive actions of the government, got it?
Yes.
All executive actions of the government of the state shall be expressed to be taken in the name of the governor, Lordship. It should be, Lordship, in the name of the governor, even paragraph 2 also, Lordship. No, it don't like. And that particular letter which was issued by the director, Lordship, by contravening the provisions of the statutory prescriptions, it's only a letter, Lordship. kita phone dia. Admission phone dia. Admission phone dia. 693 page to dia. These are the judgment I am relying, Lordship. Now, Lordship, in respect to the judgment referred by my senior sir, Lordship, regarding FRBM part, I have to, Lordship, clarify it, Lordship.
Yes, please clarify that.
They have relied 2013 1 GLR 345, Lordship. Ajit Kumar Borua and others, Lordship.
Yes.
When relying the proposition of law, Lordship, we have to go first to the facts. On what counts the Honorable Court has passed this order, Lordship. My Lord, got it?
Yes, I have it.
Lordship.
Please go on.
Lordship. Lordship, this judgment was on the basis of that there is only 2005 Act was there. There is no rules, statutory rules is there, Lordship. While this judgment was passed, Lordship, while this advertisement was issued, Lordship, only 2005 Act is there, Lordship. There is no rule at that relevant point of time, Lordship. I place it, Lordship, by way of this judgment, just I give the substance. And the basis of the judgment is, Lordship, there was a rule in 1981, Lordship. In that particular rules, Lordship, there is provisions for waiting list. But my Lord, may kindly take this book, Lordship.
1981. Page
693, Lordship. Page 693. Assam Education Department Selection Rules 1981, Lordship. On that basis, that particular judgment was passed, Lordship. Here, my Lord may kindly come to Rule 10, Lordship. It is in 696. There was a statutory prescription, Lordship. Publication of the selection list, Lordship. The selection board shall prepare a list of selection candidates for lecturers and principals, numbering at least 3 times of the existing vacancies. My Lord, may kindly mark it. 3 times of the existing vacancies, and shall forward the list so prepared to the government. The government may approve of the list so prepared by the selection board after proper verification of the charter and attendance, and publish this list in the official gazette. The list of lecturers should be published subject-wise, and the Director of Higher Education shall forward the list of candidates for the principals and lecturers approved by the government, the governing body. There was a rule, Lordship. That rule is specifically prescribed for, Lordship, preparation of a select list thrice to the number of the existing vacancies, Lordship. But that particular provision is not there in Assam Employees Provincialization Rules 2010, Lordship, which is applicable in this case, Lordship. It is in page 496, Lordship. And that particular law rules was enacted as per the power conferred under section 12(1) of the Act of 2005, Lordship. 2010 rules on page 496, Lordship.
(496).
496, Lordship. 496, there is a provisions for recruitment, method of recruitment, Rule 5, Rule 7, even whole Act, Lordship. My Lord, nowhere find that particular prescriptions where the select list should be prepared thrice to the number of vacancies, Lordship.
This 1981 rules is applicable to in which case?
Like that particular case which was relied, Lordship.
No.
2013.
No, this 81 rules is for appointment of what?
Appointment of college teachers and principals, Lordship.
Then this,
Before coming into force, that rules is not no more there. Now that rule is not existence. After coming into force of the 2005 Act as well as 2010 rules, Lordship.
has been repealed.
Lordship.
By which act?
Lordship, by 2005 Act, Lordship.
Let us see the repeating clause.
Two thousand five Act is came into force, Lordship, on 22nd December 2005, Lordship. Now, under this Act, Lordship, all colleges are provincialized, Lordship.
No, what I want to know is
Lordship.
this 1981 Act has, this is rules, 1981 is rules.
1981 rules, Lordship. 1981 rules is not applicable in this case, Lordship. Our case, it is not applicable, Lordship.
No, I understand.
Lordship, Lordship.
This rules is corresponding to which act?
That 1981 rules was in the Assam Aided College Act, Lordship, on the basis of that, Lordship. And the basis of that particular judgment, which was relied. So, for that purpose, my lord may kindly come to the facts of the case, that it will be clear, Lordship.
No, just a minute. This 1981 rules does not have any origin.
Lordship, that TGO 9 rules. Lordship, Lordship.
It repeals 1977 rules.
Lordship.
Then what is 97 rules?
It is not here, Lordship.
1977 rules.
1977 rules also in respect of, Lordship, the college which was, Lordship, regulated by the grants in aid, Lordship. And before coming into force of 2005 Act, Lordship.
So your basic case is that preparation of that panel list is something extra,
Lordship.
which is not provided in the rules.
Not providing the
Director on his own had instructed to prepare the panel list.
Lordship. Finally,
Now-
that is the basic case. And
Now-
otherwise, the basis of this case, which was relied.
No, just listen.
Lordship.
If that is the case, now on what basis did you ask for the second name?
Lordship, we are not asking, Lordship.
Second name was asked for, I think.
No, we are not asking, Lordship. We are not asking. They have recommended, Lord. We are not asking, Lordship. We are not asking, Lordship.
37 is the 35 is the third candidate. Then who is the second person?
Debo Kumar, Debo Narayan, Lordship. That Debo Narayan Hazarika.
He is rejected
Yes,
because he has not submitted NOC.
Lordship.
And how his name was forwarded?
Lordship.
Deba Narayan Hazarika.
Lordship. Debo Narayan Hazarika name was forwarded, Lordship. Debo Narayan Hazarika was the first recommendation of the governing body, Lordship. The first selected candidate, Lordship, who have withdrawn from the ferry. Then, Lordship.
He withdrew.
Lordship. That she, not he, Lordship.
She.
She was withdrawn.
Where do we get that
Record is there, Lordship. Oh, we have the original record.
No, it's in the, is it there in the affidavit?
Lordship,
Have you stated that in the affidavit?
affidavit that part is.
That out of three, the first one has withdrawn.
Is there. That is there, Lordship. Paragraph 5, Lordship. Paragraph 5.
At what stage was it withdrawn?
Before Lordship recommendation. Before recommendation, Lordship. Before recommending Lordship that particular Devona which was rejected.
Paragraph 5,
Lordship.
paragraph 5,
Paragraph 5, Lordship. Paragraph 5, Lordship.
which line? What is the
Paragraph-
name?
Paragraph 5, Lordship. My Lord may
What is the name?
Miss Nilakshi Das, Lordship. That 67.67 marks, my Lord got it.
Yes.
Miss so stood fast with 67.67 marks, but Nilakshi Das by her letter dated informed the college authority that she had already accepted the proposal to join the assistant professor in the Madhavdev College, Narayanpur, where the interview took place almost simultaneously. Accordingly, requested the college not to consider her case for the above mentioned post. Accordingly, college authority submitted the proposal of so and so.
Deva Narayan Hazarika is the second person.
Lost. He is the first recommended candidate to the department.
Deva Narayan Hazarika.
Devanand Hazarika. No, before that, no recommendation was given to the department. On the basis of that particular selection was. It is not that Lordship. Nilakshi Das was first, the persons who have withdrawn Lordship, her name was recommended by the governing body. It is not a case Lordship. At no point of time, her name was recommended by the governing body to the authority Lordship.
This page number 28, this is what, this is the selection performer.
That is the Lordship, the marks obtained by the candidate Lordship.
This is annexed to the writ petition.
Lordship. It is even record also we have there. Record also that performer is there also. Then my lord, just I.
How this was obtained through RDI? Annexure 2,
Annexure 2, but it was not mentioned Lordship.
how they obtained this annexure 2?
It is not mentioned in the environment also. In respect of the annexure to environment is paragraph 5 in page 8 also.
It's not mentioned.
Nothing was there also.
Okay, that is your case.
Then Lordship, regarding that case, I have to clarify.
Which case?
Ajit Kumar Borwal Lordship, that case. That which has relied for the FRBM part Lordship. So for that purpose, my lord may kindly mark the paragraph. Lordship got it?
Yes.
Paragraph, I am relying paragraph 814 Lordship. 814, 34, 36, 37, 42, 45 and 47 Lordship. So at first, my lord may kindly come to paragraph 8 Lordship. Paragraph 8 is the basic case Lordship. Appellant lead petitioner is working in the provincial college. They claim to be qualified for empanelment of pursuant to the selection by the conducted by the state board, Assam for the post of so and so, referring to the Assam Education Department Service Rules 1981. Just I have pointed out Lordship. The appellant lead petitioner have contended that under Rule 10(1), the number of the select candidate to be empaneled should be at least 3 times of the existing vacancies Lordship. On that particular basis, the Lordship, that particular judgment was delivered. Paragraph 14 Lordship. Here challenge was that lordship by way of a letter lordship. By way of a letter, the prescriptions given in the 1981 rules was modified lordship. It is in paragraph 14 lordship. Then it is came to this court lordship. That is the fact lordship. Paragraph 14 lordship. Paragraph 14 by way of a letter 13 to 2009 lordship issued by the Principal Secretary Department, where he have said that lordship it should be prepared as per the equal number of posts lordship. That was the case lordship. Then my lord 34 and 36 lordship.
So this is a letter, but it has got a background of the FRBN.
FRBN. That's why Honorable Court says that where there is a statutory prescription is there in the 1981 rules. 1981 rules itself says that it should be traced to the existing vacancy lordship. That's why Honorable Court finding is this lordship.
What is the finding ultimately?
34 and 36, my lord, may kindly for a moment lordship. So and so counsel of the appellant, the place reliance of the decision of the so and so to emphasize that when the statutory rules are there, the vacancy will have to be filled up only according to the state rules without taking recourse of the FRBM lordship. The statutory rules is 1981 rules lordship. 1981 rules prescribe lordship, it should be traced to the existing vacancy. That's why his submission is that as because there is a prescriptions for the panel list is there, you cannot apply the FRBM Act lordship. Then my lord, paragraph 36. Mr. So and so lordship, argument submitted that the selection given have been conducted as per the provisions of 1981 rules. And there being no objection from any corner, even to the extent of participation of the appellant petitioner, learned singular says rightly in issuing the direction for the appointment of select list prepared by on the basis lordship. This is the basis of the foundation of that particular case lordship. The selection was conducted on the basis of 1981 rules lordship. Then my lord may kindly come to paragraph 45 and 47 lordship. I am relying, then paragraph 47, my lord may kindly come. At that relevant point of time, lordship, 2010 rules was not notified. That's why that paragraph was there, lordship. It was submitted that the impugned selection was conducted complying with the provisions of Act of 2005 and rules. It was also submitted that no rules have been framed under the provisions of the Act. The date same has been draft stage, lordship. That particular 2010 rules was in the draft stage, lordship. Rules for 1981 had to be followed, lordship. Even if the rule 91 has to be applied in case any conflict with the provision of the state non-statutory rules, the provision of Act 2005, needless to say that the provision of 2005 would appeal. If the draft rules frame under 2005 Act, which has been finally published in the Gazette on so and so, known as so and so, the mandate therein in such tune with the provisions of the Section 6 of 2005 Act, lordship. At that when the advertisement was issued, lordship, that particular 2010 rules was never published, lordship. That's why that particular advertisement was on the basis of, lordship, 1981 rules, where there is a provisions of the panel list of thrice of existing vacancies, lordship. Whereas in 2010 rules, after coming into force of 2010 rules, lordship, there is no provisions of panel provision, lordship. That's why that particular case is totally not applicable here, lordship. The fact is totally different. And in respect to other judgment, lordship.
What is this 2005 Act referred here?
Lordship.
Provincialization Act.
Provincial Act, that is that particular act which I am relying, Lordship. On that paragraph, Lordship, page 490, Lordship. The rule making power is page 12, Lordship. In that particular case, Lordship, that Ajit Kumar Borua, which was relied by my senior friend, the Lordship interview was held in 2009, Lordship, prior to the comments of the act coming into force of the Act of Rules of 2010, Lordship. That's why Honorable Court says that as because the advertisement was carried out on the basis of 1981 rules, where there is a provision is there, ties to the existing vacancy, that's why the FRBM will not come into place as because there is a statutory rules is there also. So Lordship, that particular case is not applicable here. And rule making power is Lordship 495 page. Rule section 12, Lordship. Pero ¿qué avanzó ese asunto, no? Tú continúa. Que no te puedas dejar. Que no puedas hacer eso. And Lordship, rule is page 496, Lordship. That rule came into force, my lord, may kindly mark it 15 November 2010, Lordship.
No, what I was referring to this in Ajit Kumar Barua's case,
Lordship.
2005 rules,
Ajit Kumar Borua's case 2005 Act, Lordship, not rules. Act.
2005 Act.
Act.
Correct.
Yes, because at that relevant point of time, there was no rules was there, only act is there, Lordship. Act is there, rule never come, Lordship. The advertisement was issued, Lordship, on the selection process was completed on 18/3/2009 in this case, Lordship, particular case. Ajit Kumar Borua's case, Lordship, 18/3/2009, Lordship. And our rule is come, Lordship, on 15 November 2010, Lordship. 1510. That's why Honorable Court says that as because the advertisement was carried out on the basis of 1981 rules, where there is a prescribed provision is there, that's why, Lordship, the FRBM will not come into place, Lordship. That is the reason, Lordship. And otherwise also, Lordship, if my lord may, for a moment, my lord may held that FRBM is not come into place, Lordship, then also petitioner case is not come within the ambit of the Lordship 2010 rules, Lordship. There is no provisions for preparing a panel list or Lordship wait list, Lordship. Statute, there should be a prescription in the statute. That prescription is not there, Lordship. When that prescription is not there, Lordship, that is not enforceable, Lordship. Even for a moment, Lordship, I am abandon my argument in respect of Lordship FRBM also. Then also he is not entitled, Lordship. She is not his Lordship, she is not entitled, Lordship. My lord, very specific, paragraph 42, my lord, may kindly come. Paragraph 42, lordship. Forty-two, the argument that in absence of any rules and guidelines to implement the provisions of section 6 of 2005 Act, at the relevant point of time, no rules is there, lordship. Rules and guidelines, there was nothing wrong to fall back to rules 1981. As because, lordship, the advertisement was issued, lordship, on 18/3/2009, lordship. Before coming into force of this act, lordship. Rules, lordship, rules. That's why, lordship, that particular judgment is totally not applicable here. At the relevant point of time, when selection was conducted in the Ajit Kumar Borua's case, lordship, the rule of 2010 is not there. So, the authority applied the provisions prescribed in 1981 rules, lordship.
Okay, please wind up your argument.
Lordship. Then Arjit Pal case, lordship, just last submission, my. Arjit Pal case, which was relied by my senior, lordship.
Yes.
It is totally a different footing, lordship. It is a just a substance I point out, lordship. It is a case, lordship, where the governing body recommended the lordship, the persons who have obtained the second position of the marks, lordship. He was recommended by the governing body. Then directorate has rejected his claim that first position candidate is there. You cannot recommend the lordship. The second highest, the persons who have obtained the second highest marks, lordship. That is the case, paragraph 4, lordship. On that basis, that particular candidate came before the Honorable Court. Honorable Court allowed his writ petitions, the first candidate, lordship, and directed him to appoint, lordship. And in that particular case, the nominee, which was lordship referred by the selection committee, who have obtained the second highest mark, he come into the appeal, lordship. Then Honorable Court upheld the decision of the single bench, lordship, holding that there is no fault regarding the recommendation of the first highest marks candidate, lordship. And ultimately, lordship, both candidates are not joined. It is go for first selection, lordship. Totally defined footing. Okay. So, lordship, I sum up my argument by saying that, lordship, there is no provisions or prescription in the statute for preparing a panel list. As per the law laid down by the Honorable Apex Court, lordship, the recommendation we cannot act upon. It is beyond the scope and power given to the legislature, lordship.
All right.
Oblige, lordship.
Principal?
Yes.
Will not be necessary.
And I'm appear on behalf of governing body as well as principal, my lord. Also file affidavit, my lord. Before, my lord, please may kindly see in my affidavit, my lord.
Mr. Gogoi, just one thing you just mark in the record. That's record by the record of the. What is that record?
Governing body, that's one.
Governing body. But you're for the director, isn't it?
Yet after lordship selecting everything, lordship, they have forwarded to us it to act upon the on the basis of the selection, lordship.
There is no dispute regarding forwarding of number 2. One had declined.
One had declined.
So 2 has forwarded. Okay, that
was forwarded.
nobody disputes that, isn't
Nobody
it?
disputes.
All right.
One was never forwarded, lordship.
Was never forwarded.
Never forwarded.
All right. Yes.
Yes, my lord. When this 2 vacancy was occurred in our college, my lord.
Yes.
We send a letter to the authority, my lord. And authority, my lord, please may kindly see page 58 in my affidavit, my lord. And we praying for the accord of permission for advertisement and director higher education. That was already reading, my lord. Page 58, last portion, my lord.
Yes, we've
that
read
to-
this.
Yes, already written in the event of one candidate joining elsewhere. This letter was issued on 27/6/2017. And thereafter advertisement was issued on 15/7. 27/6/2017. Thereafter we issued an advertisement on 15/7/2002 post. On the basis.
Permit, I can reproceed.
Yes.
Number 10 on the-
Yes, yes.
On the basis of that, my lord, permission, they given the all condition, what qualifications are required, educational qualification, all are in 1, 2, 3, 4, 5, and thereafter they also said that in the event of one candidate joining elsewhere or not offering to join, the appointing authority may go for preparing select list up to candidate number 3 in the comparative statement and not beyond the subject to the approval of the governing body. This is for avoiding successive re-advertisement for the same post. Because of suppose they are not coming to 1, 2, 3. So thereby they says that, my lord, you can select a 3 person because of the again you cannot for the purpose of the entire expenditure incurred by the college authority. So thereby they says that you issue the advertisement and you select in order of merit 3, my lord. And thereafter advertisement was issued and a select list was prepared, page 61, my lord, in my affidavit of position. And when select list first candidate, Miss Nilakshi Das, is given a letter to inability to join is the assistant professor political science. And thereafter, my lord, we acknowledge the same, and thereafter we forward the approval for appointment is second in Debo Narayan Hazarika.
You tell me one thing, I've understood the facts. Okay.
Yes, yes.
Is your submission going to be a bit different from what Mr. Gogoi had
No,
submitted?
we are not. I'm only that they all record is the same. And thereafter Debo Hazarika, he is working in another higher secondary school.
No,
NOC is required. They
See,
did
I've
not,
understood
thereby
all those things.
they
See,
rejected.
See,
And
due to time constraint, you
Yes.
don't have to repeat everything. I've
thereafter
understood.
what happened, my lord?
Only thing which
No,
additionally,
before that, my lord, I am saying, my lord.
just listen to me.
My lord.
Additionally to what Mr. Gogoi says, in this point, I need to add this. You add that.
Yes, ma'am.
Otherwise, you don't have to go from the beginning again, one by one.
No,
Not
I'm
required.
only one point. Before filing the, my lord, writ petition, my lord, serial number 3 was given for approval, my lord. That is the main point, my lord.
Serial number 3 was?
Yes, my lord. My lord, serial number writ petitioner name was forwarded for approval. Before filing the writ petition by the second one, my lord, Debo Narayan, my lord. Before filing the writ petition, this application was pending before the Director of Higher Education. My page 67, page 20. And thereafter, Debo Narayan came before the Honorable Court, and Honorable Court passed an interim order, staying the
Number 2 came before the court.
Yes, ma'am.
Number
Number
two
2 came before the court, and thereafter the stay order was passed. And in the meantime, thereafter he withdrew the petition, and Honorable Court last line observed that, my lord, page 69.
Yes.
It is made clear that on closure of the writ petition and vacation of the interim order, the college authority may go ahead in accordance with law. Page 69. In my affidavit.
The page number doesn't tally. This is a problem.
My affidavit in opposition.
But I've seen it somewhere.
Yes. And thereafter, my lord, what happened? One order has been again passed by, yes, madam, principal. I sent a letter by the principal on after passing the final order by the Honorable Court 19/3/2022 regarding approval appointment assistant professor, so and so page 70, my lord. Further, the Honorable Guwahati High Court interim order passed earlier and vacated and ordered the college authority go ahead in accordance with the procedure. Sir, may I request you to look in the matter as per Honorable Guwahati High Court regarding, so this was issued by the principal to the director. And thereafter, director issued that order, my lord. Please kindly see. Again, my lord. That is not in one director. The earlier is Babulal Sharma, next in Dharmakanto Milli, my lord. Page 71. Regarding approval of appointment assistant professor of political science, your letter number so-and-so dated so-and-so. In inviting reference to the subject cited above, I would like to request you to take necessary action for approval appointment of assistant professor political science department to your college as per direction of the Honorable High Court order passed in so-and-so.
Then what happened?
Filed so-and-so.
Then what happened?
Thereafter, my lord, this is my lord, application is pending till today. Okay. We are problem is that my last 2017, my
No,
lord.
after this 19/3/2022, page 70,
My lord.
the present writ petition was filed. Is it?
Yes, my lord. My lord, last from 2017 onwards, my lord, entire college is suffering as well as student community, my lord. Because of either way, my lord, but one teacher is required. This is my humble and respectful.
Yes, Mr. Mahanta, any reply?
My lord, it appears that I am to argue my case afresh. Kindly see. The argument advanced on behalf of the director is wholly based on wrong conception, misinterpretation of the rules. It has been repeatedly argued that there was a violation or acting against the statutory rules. What is that? What amounts to acting contrary to statutory rules? What amounts to violating the statutory provisions of law? Is very clear. When there is a positive direction to do in a certain manner, and the authority acts quite opposite to it, then it is called acting contrary to or violation of the particular provision. Here, what is that violation? Kindly take up the rules again. That's why while opening my argument, I submitted that it is the government who is making the case complicated because of their own wrong perception. What does it say? The rule, firstly, act must provide, and provisions of the act are given effect to in the rules. That is the structure. In the act, Assam College Employees Provincialization Act 2005, Section 6, Lordship will kindly take up once more.
Yes.
What does it say? Kindly see. Appointments of both teaching and non-teaching posts in the college shall be made by the Director of Higher Education Assam on the basis of selection and recommendation of the governing body of the respective college in accordance with the rules and procedure of the government in force. So selection is to be made by the governing body in accordance with the rules. Now kindly come to the rules.
Rule 5.
Why? Here, recruitment shall be made in the manner prescribed herein after. Well, it first relates to the principal. Let us see this also one. Appointment to the post of principal shall be by direct selection. For this, the governing body shall constitute a selection committee which shall select a person on the basis of an interview from amongst eligible candidates who apply in response to an open advertisement in newspapers. The governing body shall recommend this candidate to the director who shall issue orders of appointment. My lord, now here I will pause for a moment. Lordship will kindly see this. This particular sub rule specifically says about the selection of the for the post of principal, and it says that they constitute a selection committee which shall select a person. Kindly note this.
We are concerned with lecturer.
No, we are coming to this, but comparison of the rules I am trying to make out how it differs. Whether we can read this here also for the case of the lecturers. In principal's case, this has been very specifically said.
No, thing, Mr. Manta, see, select, there's no issue.
No,
Only
they are
issue
saying,
now is whether you can have a panel list and panel list can be acted upon.
well, that is,
That's
in
all.
making selection, whether they can make a select list.
They can make a list, why not?
Then in that select list, whether it can contain 3 or it can contain 1.
Exactly.
Yes, whether there is an embargo by the rules to make the selection only with respect to 1 candidate. Whether it is there.
FRBM, that's what they say.
FRBM they are trying to bring in, but where is the rule? They are saying that in the rule the director has also violated the rule by issuing that letter, and selection has also been made by making a waiting list. Firstly, they are confusing that a select list and a waiting list. Waiting list is different.
See, it says also which shall select a person.
A person in the case of principal.
A person.
Yes.
And the next one?
A person in the case of principal, a person on the basis of an interview from amongst the eligible candidates who apply in the response to an open advertisement in newspapers, the governing body shall recommend this candidate. Whether the language is same in the latter part, let us see that. The governing body shall recommend only that candidate. And selection body must select a person. That is, Lordship has noted. Now, for the post of lecturer librarian, appointment shall be made by direct recruitment with prescribed qualifications through open advertisement in 2 leading dailies. This procedure has been laid down. How? At least in 2 consecutive issues. In respect of grade 3 and grade 4 posts, a list of candidates shall be collected from the local employment exchange, advertisement in newspaper. That's all. It has not said any further. Only said that it should be circulated in 2 newspapers. Appointment of head assistant shall be made by promotion, that we can skip. Appointment to the post of upper division assistant shall be made on promotion. That is, again, the post of lower division assistant, library, they also in ratio. Placement of lecturers, librarians in selection grade, senior skill grade shall be made done by the governing body. It is not required to us. Then 7, sub-rule 7, in all these cases, the governing body shall conduct the selection process and recommend to the director who shall issue orders of appointment. That is the final dictum. Then again, rule 7 is very specific. 6 also, assessment of vacancies. Here, we may skip that 6 for the time being. Direct recruitment rule 7, all appointments either by direct recruitment or by promotion shall be made by the director on the basis of recommendations. Recommendations of the governing body based on the recommendations of selection committee, departmental promotion committee duly constituted. Recommendations of the governing body and recommendations of the selection committee. It does not. B says the director shall communicate his orders within 30 days. And then C says the selection committee may hold such test or interview for all posts as may be considered necessary. For posts for which UGC has prescribed norms, no candidate shall be recruited without having the required norms. All fresh appointments shall be made on receipt of police verification report. This is the procedure prescribed. Does it say that the selection committee shall prepare a select list of only 1 candidate? Or equal to the number of posts. My lord, something which is not specifically prescribed in the law, in the rules, we cannot read the negative there. That means if there is no specific provision that you cannot make a panel, there shall be no panel, no waiting list, yes, then they cannot do. The selection committee or the appointing authority cannot go make a device of their own. This is the law. Now here it is open. Here it is open. Here, no such embargo has been put. Selection should be made. You can make recommendations. And it is select list, no waiting list here. My learned friend was arguing that.
That is the best part of the thing, you see. That leaves room for argument from both sides. One will say that there is no bar. One will say there is no provision.
That's Lordship will have to
So-
decide now. My
This is-
question is, that was a wrong interpretation given on the face of these rules. Yes, I would have agreed had there been a provision specific here saying that you cannot make a selection in this way. You cannot prepare a list beyond one or two candidates, or you cannot make a waiting list. Yes, then one can very well say that you have acted illegally contrary to that rules. But now to say that selecting making a select list of 3 candidates is per se violative of the rules is apparently unfounded. I do not find any restriction here in the rules. Rather, it has kept it open.
That's why that FRBN was relied upon.
FRBM, whether it can be brought into, that is to be said separately. So far, first the preparation and in making this select list is concerned, I am on that. He was arguing that even keeping aside the FRBN for the time being, the whole selection itself is wrong, and the direction of the letter written by the director for preparing a select list of 3 candidates is apparently violative of the rules. What is that? I am examining that. I am making a submission on that point that this is unfounded totally. Submission is totally unfounded. And when, my lord, Lordship will kindly appreciate, and Lordship knows it well, that when there is some gap, there is something not specifically provided in the rules, the authority who is bound to implement it can always supplement by making a clarification, by issuing a letter or a memorandum. This is always permissible. This is always permissible. And they have every right to do that. But kindly say, not to defeat the purpose of the rules or act, but to enhance, to achieve the purpose, to enhance the quality, grade in selection. And here also, the director has very clearly mentioned that you go for a panel of 3, select list. You prepare a select list of 3 candidates. That is what? Page 24.
Yes.
You have seen it, my lord. Select list doesn't say the waiting list or panel. It says a select list. You make a select list of 3 candidates so that we can avoid repeated advertisement. Repeated advertisement. What for? To save time, to save money by giving advertisement every time. Undertaking the same process repeatedly, again and again. So, when there is nothing specific in the rules, the director has every right to issue that letter, and this cannot be at any rate be argued as contrary to the rules. In my full submission, the whole submission is unfounded. The whole submission of the other side is unfounded. And kindly see, my lord. Director is the authority, appointing authority. If he would have found that his earlier letter is wrong or illegal, he could have withdrawn it at any time subsequently. Did he do it? No. What prevented them? That no, don't go like this. Now you go for this. I'm issuing a fresh letter. Was it done? No. Now suddenly he turns around and says, that is why I submitted initially, that he is trying to blow hot and cold at the same time. Now he has changed his stand. How can he change his stand? No, to the prejudice of everyone. To the prejudice of everyone. How can he be allowed to argue this? But he had the authority to withdraw it at any time, subsequently saying that now first, and you see here is a panel of only two. Select list contain ultimately two persons. One has already declined.
One was never forwarded.
Never, not forward, because he has, having come to know that he has been selected as first candidate, he immediately contacted and said, no, sorry, I will not come. Kindly do not keep me in the list. So he had done. So two remained. And when the second was forwarded, the whole file was forwarded. Whole file was forwarded. They found that panel, they found that select list containing 3, then 1 gone, 2 were there, then 1 was forwarded. That time also he could have raised that no, you could not have prepared the panel of the 2 candidates or 3 candidates. That was not done. That was not done. But it said that because of NOC issue, second could not be recommended. And after that disposal of the writ petition, what was his stand? Director then again wrote, kindly see at page.
Mr. Manta,
My lord.
I think we can close the matter.
My lord, just only a clarification to that. I will not dwell on much because Lordship has heard enough and enough. But it is my duty to point out certain things which in my resource submission not sustainable in law, rather contrary to law. The submissions of the other side. Page 45. When my lord Lordship inquired this, page 45 of the writ petition annexure 11, when the writ petition was disposed of, filed by the second in the panel, but or the first one who remained ultimately, then the director has written to the principal again that regarding approval of appointment of assistant professor, political science department, dated 27/4/2022, my lord, this letter.
Director has written.
Yes, director has written.
Page number?
Page 45.
Of the writ petition.
Yes. Annexure 11. Don't you got it?
Yes.
Yes, this is the letter by the Director of Higher Education to the principal regarding subject, regarding approval of appointment of assistant professor, political science department, reference letter number, appointment so-and-so, 19/3/2022. In inviting a reference to the subject cited above, I would like to request you to take necessary action for approval of appointment of assistant professor, political science department of your college as per direction of the Honorable Guwahati High Court, dated so-and-so, passed in WPC number so-and-so, filed by Debo Narayan Hazarika versus State of Assam.
Okay, Mr. Manta, we'll close it.
I hope
This has been pending for quite some time.
My lord, it was pending quite for some time. It was.
So let me try to dispose of the matter just now. Mr. Manta.
We'll obviously, my lord, expect this and we hope.
I will consider and pass the order. Okay.
Lordship will kindly, one more clarification probably, I will just indicate my lord, the decisions which has been referred to by my learned friend, Mr. Gogol. Here also, Lordship has seen this. There something is else, it is not directly applicable to our case. But here, select list and waiting list. There's 2 things right there. Waiting list gets the emphasis that unless waiting rules provides for waiting list, you cannot have a waiting list.
All right.
That is, my lord, otherwise,
okay.
I have marked this, but
Okay, Mr.
I
Manta.
find I will not dwell much. I will leave you to your lordship. Lordship will look into it. Only let me see if it needs.
Mr. Manta, please take your seat. I'm passing the order.
I am greatly obliged, my lord.
Heard Mr. K.K. Manta, learned senior counsel, assisted by Mr.
DK Das.
D.K. Das for the petitioner. Staff also heard Mr. K. Gogoi, learned standing counsel, Higher Education Department. appearing for the respondent numbers 1 and 2. And Mr. N. Bora, learned counsel appearing for the respondent number 3 and 4. Stop. The controversy in the instant writ petition is in respect of the selection and appointment of a suitable candidate to the post of assistant professor in political science in Sonari College, Sibsagar. Stop. An advertisement dated an advertisement was floated by the principal of the college in the local daily, the Assam Tribune, on 15/7/2017 for filling up the said post, along with another post of assistant professor in zoology. Stop. The post of assistant professor in political science was reserved for a scheduled caste candidate. Stop. Responding to the advertisement, the instant writ petitioner, along with other candidates, participated in the selection process. And the selection committee shortlisted 3 candidates, including the writ petitioner, for the said post. Stop. From the comparative statement annexed by the writ petitioner, the petitioner stood at number 3 in order of preference. And as per the marks code. Stop. There is no dispute at the bar that the candidate who scored the highest mark turned down the offer even before the results of the selection was forwarded to the Director of Higher Education. Stop. The candidate who scored the second highest marks was then required to submit a no objection certificate, bracket NOC, in view of the fact that he was working. Where was he working?
Secondary school.
At Nahar Kotia
Yeah.
Higher Secondary School. Stop. However, as he could not submit the NOC, the name of the instant writ petitioner was proposed to be considered for appointment to the said post. While the person who scored the second highest marks stood rejected for want of NOC. Stop aggrieved. The second, the said candidate approached this court by filing WPC number 1355 of 2018. And the instant writ petitioner was arrayed as respondent number 6. Stop. This court on 12/3/2018, while issuing notice of motion, passed an interim order to the effect that the post of assistant professor in political science in the college shall not be filled up by the respondent number 6 in that writ petition or by any other person until further orders. Stop. However, the said writ petitioner ultimately decided not to pursue his writ petition and sought for withdrawal of the writ petition. Full stop. This court, by order dated 11/3/2022, permitted withdrawal of the writ petition with a further observation that the college authorities may go ahead with the matter in accordance with law in view of the closure of the writ petition. And the stay order being vacated. Stop. Thereafter, the principal of the college, while letter dated 19/3/2022, wrote to the Director of Higher Education to look into the matter. In terms of the court's direction. Stop. However, as no further steps was taken, the instant writ petitioner approached this court through this writ petition. Next, para.
Sorry. Thereafter, that was forwarded. My name was again forwarded by the college authority. Pursuant to that letter, my lord.
Okay, sorry.
Page 45.
45.
Page 45 letter. Thereafter, my name was recommended.
Before passing the review order, my lord, the petitioner name was forwarded to the director.
Before?
Before passing the review order. interim order passed on, my lord, 12/3/2018, page 40 of the petition. And approval for writ petitioner on 24/1/2018.
I'll just go back and say that part which I've said, na, that the post should not be filled by the respondent number 7 or any other person. I'd say that, no? Be it stated herein that even before the passing of the interim order, the name of the present writ petitioner had already been forwarded to the director for considering his appointment. Her appointment. Then forwarding of the name of the standard petitioner. The principal of the college also by letter dated 23/5/2022 forwarded the name of the petitioner to the Director of Higher Education. For approval of his appointment, the post in question. Despite the same, since no further steps was taken, the present writ petition has been filed by the instant writ petitioner. Next para. Prayer made in the writ petition is for a direction to the respondent. Number 2, to approve the resolution dated 8/1/2018 of the governing body of the college and to appoint the petitioner as the assistant professor in political science. Next para, Mr. K. Manta, Learned Senior Counsel, submits that the advertisement floated in the local daily on 15/7/2017 was preceded by the permission given by the respondent number 2 on 27/6/2017, which was communicated to the college principal. Stopping the said communication, it was specifically indicated that in the event the first candidate joining elsewhere or not offering to join, the appointing authority may go for preparation of select list up to candidate number 3 in the comparative statement and not beyond. which shall however be subject to the approval of the governing body. Stop. This was for the purpose of avoiding successive re-advertisement for the same post. Stop. He submits that since the candidate who scored the highest marks
He withdraw his name.
withdrew herself from the post in question, while the candidate scoring the second highest failed to produce an NOC.
And also abandoned the claim lastly. Lastly abandoned the claim. He abandoned the claim. He said that I am joining elsewhere.
NOC from his employer, and ultimately withdrew his claim the respondent authority concerned. No, cancel that. It was therefore incumbent upon the respondent authority concerned to accept the resolution of the governing body and appoint the writ petitioner to the post in question. Stop. However, the respondent number 2 by taking a contrary view has failed has refused to appoint the petitioner to the post in question on the ground that the relevant rules do not provide for the preparation of a panel list Stop. He submits that the same cannot be accepted. In view of the fact that the relevant rules, that is the Assam College Employees bracket provincialization rules, comma 2010 bracket rules of 2010, and the act and the act itself, that is the Assam College Employees bracket Provincialization Act, comma 2005 bracket Act of 2005 itself do not bar preparation of panel list. Stop. The learned senior counsel further submits that according to the respondent number 2, the select list for appointment to vacant sanction post should contain names equal to the number of vacant posts notified at the time of calling for applications for filling up the post. In terms of the Assam Fiscal Responsibility and Budget Management Act, 2005. Bracket FRBM Act, close bracket, stop. The learned senior counsel submits that the said provision cannot be pressed into service in the instant case in view of the fact that the rules applicable in the instant case is the rules of 2005, which nowhere prohibits preparation of panel list. And importantly, in view of the clear permission and instruction given by the respondent number 2 through communication dated 27/6/2017. Stop. He also submits that the FRBM Act has been enacted to ensure fiscal stability and transparency in management of public finances of the state, amongst others. Stop. That preparation of select list up to the third candidate as per communication dated 27/6/2017 is also for the purpose of austerity measure and to avoid successive advertisements for the said post. referring to Section 6 of the Act of 2005 and Rule 5 bracket 1, comma, bracket 2 and bracket 7 and also Rule 7 of the Rules of 2010 amongst others, comma, the learned senior counsel submits that the FRBM Act cannot place an embargo upon the respondent authority concerned. Not to act upon its recommendation to appoint the petitioner to the post in question. Not to appoint, that cancel it, for appointing the petitioner to the post in question. He thus submits that the petitioner, having waited for his chance to be appointed since the selection which was held in the month of September 2017, and the college having functioned without a teacher in political science, court may direct the respondent authorities to act upon the recommendation made by the governing body and accordingly appoint the petitioner to the post in question. So in support of his submission, the learned senior counsel has relied upon the following authorities. Number 1, Dr. Ajit Kumar Barua and others versus State of Assam and others. 2013, 1 GLR 345. And number 2, Arjit Paul versus State of Assam and others. 2019, 1 GLT 87. Next para, per contra, Mr. K. Gogoi, Learned Standing Council, Higher Education, submits that there is no provision in the Act of 2005 and the rules of 2010 which provides for preparation of a panel list or a waiting list. And therefore, in the absence of any provision, the writ petitioner, who admittedly had scored the third highest marks, cannot be given the benefit of appointment. Stop. He submits that no doubt the candidate who scored the highest mark withdrew herself from the process of selection. From the post, not process, from the post.
Contest, Lordship, from the contest.
From the from contesting for the post. It was the candidate who scored the second highest, who ultimately was forwarded to the respondent number 2 for consideration and appointment. Stop. However, since the said candidate not only failed to produce NOC from his employer, but also ultimately withdrew himself from contesting for the post, the writ petitioner, the instant writ petitioner does not come anywhere in the picture. And what would be required is to go for a fresh selection. Stop. He submits that the FRBM Act clearly provides that the select list should contain names of the candidate equal to the number of vacant posts and not otherwise. Stop. The respondent number 2 no, cancel that. The communication dated
Twenty-seven, 6/2017. Page 27.
27/6/2017 is not backed by any provisions of the relevant rules governing the field and cannot be the basis for making a claim for appointment to the post in question. The affidavit. In support of his submission, the learned standing counsel has relied upon the following authorities. Column dash number 1. Valampati Satish Babu versus State of Andhra Pradesh and others. AIR 2025, 2022 SC 2949. Number 2, State of Uttar Pradesh versus Karunesh Kumar and others. AIR 2023 SC 52. Number 3, Employees State Insurance Corporation versus Union of India and others. 2022 11 SCC 392. Number 4, R. Rajit Singh and others versus State of Tamil Nadu and others. 2025 SCC online SC 1009. Number 5, Union of India and others versus Mahendra Singh. 2022 SCC online SC 909. Number 6, Mrinal Kumar Bora bracket Doctor versus State of Assam and others. 2017 1 GLT 737. And number 7, Dhanraj versus Vikram Singh and others. 2023 SCC online SC 724. Next para, Mr. S. Bora, learned counsel appearing for the college. N. Bora, adopting the argument made by Mr. K. Gogoi, also submits that after the writ petition filed by the candidate who scored the second highest marks was disposed of on 11/3/2022 with a direction to the college authorities to go ahead in accordance with law. The principal of the college had written to the director, higher education, to look into the matter. Wide letter dated 19/3/2022, and thereafter had forwarded the name of the writ petitioner for approval and appointment. Wide letter dated 23/5/2022. Such a step was taken on account of the fact that the candidate who scored the second highest marks failed to produce NOC from his employer, and his case was therefore rejected. Although he filed a writ petition before this court, but later on he withdrew the same, and therefore the college principal had to, and the college principal forwarded the resolution of the governing body, wherein the name of the petitioner was suggested for approval and appointment, since he had scored the third highest marks in the selection process. Mr. Bora, anything else?
That might not, we are selected the petitioner, right? Permission.
Correct, okay.
That particular.
He further submits that the name of the petitioner has figured for considering for approval and appointment only in terms of the instructions and permission given by the respondent number two through the communication dated
27/6/2017.
27/6/2017.
But instruction was not given to us regarding to act.
Stop. He also submits that no further instruction was given to the college. Pursuant to the said instruction. I think that much only.
And with respect to his concern also, he candidate was selected or any other. You choose that one political.
Yes.
During his concern also, he was selected. One, two, three, he was not other male.
And who was appointed? So there's no issue on that. Is that your statement in your affidavit?
But this is the instruction I'm taking for the.
Then we'll not include it if it's not the affidavit. To stop, he therefore submits that under the facts and circumstances, court may consider and pass appropriate orders. I was thinking of disposing it of, but I think we are out of time. So I'll rest it at that. Right?
Deeply obliged, my lord. Deeply obliged so that the matter will see the light of the day. It appears now. Yes, yes.
My lord, in respect of item number 12, my lord, the petitioner is under suspension, my lord, since last 7 months. Item 12, my lord. The petitioner is under suspension since last 7 months, my lord. So, my lord, I will take up the matter on Thursday, my lord. Day after tomorrow, my lord.
You write one more line, heard Mr. So-and-so, so-and-so. Hearing concluded, judgment reserved, okay? Let it be CAVM. Item 12,
My lord,
first day.
Thursday, my lord,
This
if
is-
possible, my lord.
This is regarding suspension.
Suspension, my lord. He is under suspension since last 7 months, my lord.
It is, Hmm?
My friend is there for the BTC, my lord.
Let it come next week on a hearing date.
On 3rd, my lord, 4th, my lord,
Tuesday.
my lord.
All right. Let's wait for by the parties list this matter on 4th of
So item number
Okay,
26, Lordship.
October, 4th of November
So item number 26,
for admission hearing.
item number 26, Lordship. Can it be on 11th, Lordship? This is 2020 matter, Lordship, it was once finally hard and fixed for judgment, Lordship.
He wanted on 11.
Uh,
26.
Lordship, can it be on 11th, Lordship?
Okay, 11th. That's paid for. List the matter on 11th.
Obliged.
For hearing.
Oh,
One more left. 27. Anybody? Oh, there's 17, 18, 27 are there. Hmm. Will this after 2 weeks? All the cases, remaining cases, okay.